2025, 9 a.m.
Thank you.
What day would that be?
That's Thursday, October 16th.
Okay, I'm gonna go back and write it down, okay? Thank you very much.
Thank you.
Thank you.
Bond will continue. Court does call the case of the people versus Alicia Cargill.
Andrew Bannis for the people.
Killawald here. Anybody see Mr. Killawald? Anyway, let me pass that one briefly. Yes. Court does call the case of the people versus Aaron Hudge Peterson.
Andrew Bannis for the people.
Morning, Your Honor. Dan Garrett on behalf of Mr. Hudge Peterson.
Aaron Hudge Peterson, Your Honor.
Thank you, sir.
Your Honor, you're gonna love this. May I approach for all of 30 seconds with Mr. Bannis?
Pardon?
May we approach for 30 seconds?
Yes.
Thank you.
Briefly.
You want me to?
Discuss, Your Honor, some bond considerations. I'll discuss that with Mr. Bannis as well.
All right. How long will it take you to get some of that? Will the 16th work for you?
That'd be great, Your Honor. Thank you.
All right. Probable cause conference, October 16th, 2025, 9 a.m. bound completion.
Thank you very much, Your Honor.
Thank you. Court does call the case of the people versus Timothy Flood.
Ready, Your Honor.
Under Joe Simon, on behalf of Mr. Flood, state your name, Timothy. Timothy Flood.
Thank you.
Your Honor, Ms. Willenbringer and I have been in discussions. She tells me the matter is going to be handed off to a different APA. I've made a proposed resolution. We're asking for an adjourned PCC to continue those discussions.
That's correct, Your Honor.
Probable cause conference, October 9th.
Your Honor, I'm traveling that day. I know I have another one that day, but I'm actually going to have someone cover. Could we have the next available, please?
16th, 2025, 9 a.m.
Thank you, Your Honor. Wait for me. Actually, just go home. Go home.
The court calls the case people versus Jamie Burke.
Andrew Bannis for the people.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Burke. Mr. Burke, could you state your full name for the record?
Absolutely. Good morning, Your Honor. My name is Jamie Burke.
Thank you.
Your Honor, at this time, we are requesting a preliminary examination. To my knowledge, discovery is complete.
Where's my day? No, I can't. Oh, no, you're right.
Yeah.
All right. People have their witnesses available October 14th.
I believe so, Your Honor.
Preliminary examination without objection, October 14th, 2025, 9 a.m. before Judge Washington.
Thank you.
Thank you, Your Honor.
Thank you. Bound continue. Court does call the case people versus Amanda Lawrence.
Ready, Your Honor. Seconds good.
My recalls. My recalls.
Andrew Bannis for the people.
Your Honor, Joe Simon, on behalf of Ms. Lawrence, state your name, Amanda.
Amanda Lawrence.
Your Honor, I became engaged yesterday and we substituted in.
I think it's already married.
Ha. You know what the
It
penalty?
was too easy, Joe.
Do you know what the penalty for bigamy is, Your Honor?
I do. You know.
Two mother-in-law. No, go ahead. No, sorry.
Wow.
No, that's what I heard. I And anyway,
Wow. Wait, you said that out loud.
I know. It's an
You
oldie.
want an adjournment,
It's an
right?
oldie. Yes, please.
Wow.
Ah.
On behalf of Mr. Simon, I apologize. October 16, 2025, 9 a.m. Bond
Thank
continued.
you, Your Honor.
Wow. Go. Get that way? Never mind. You're not even getting into it. Court calls the case, People versus Devontae Connor Belcher.
And on behalf of the people,
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Connor.
Guys, you're
Bell.
gonna have to make sure you make room for transport to get through. And pay attention when they're coming through. Your name, sir?
Devontae.
Yeah.
Your Honor, we're asking to set this matter for a preliminary examination.
Discovery is complete.
Yes, Judge, to the best of my knowledge.
Preliminary examination in this matter will be in person, October 14th, 2025, 9 a.m. before Judge Valvo.
Can we hear on bond, Judge?
Briefly,
Thank you. Mr. Connor Belcher is here. I have his father is also here in court. His father has indicated that he can reside with him during the pendency of this matter. Mr. Belcher is stays in Ann Arbor. I don't think he's a flight risk. In this matter, he could be tethered. I'm not going to gild the lily. His father did indicate he lives at Avalon. But I think the 14-day rule for guests would be pretty well satisfied.
not an object any minor police this case involves the defendant stiff arming the victim in the chest and stomach multiple times and strangling the victim. He also has told in this county, he has 2 retail products second hold out of 1481 that's up on 15 the 1,010% bond. He also has a wrong disorderly out of 15 that's up 1023 with the 1,010%. He also has hold out of Bologna for disorderly for $585 and failure of fraud with 5,010% bond. So at this point, I'd be asking the property to set.
Your Honor, in looking at XGL, I don't see that the out county jurisdictions would are looking to pick them up on these, and the bonds in the other cases total to $300 to them.
court, in considering all of that, the court is going to deny the request to modify bond at this time. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Jack Sophia.
Yeah,
Prosecutor,
good morning, Tom Pietrowski on behalf of Mr. Sophia. Jack, identify yourself, please. State your name and get unmuted.
Jack Sophia Jr.
Thank you, sir.
I need a camera, sir, but go ahead. What are we doing?
We'd be, after discussion with Mr. Sophia, we would be waiving the exam, Your Honor. This is a case to be bound over.
Sir? You're going to waive your right to a preliminary examination?
Unmute, Jack. Unmute, Jack.
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
yes,
People also waive their right.
We do.
Preliminary examination having been waived, defendant bound over to circuit court on count 1 with 2 following. Mr. Petros.
We waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 25th at 1:30 with Judge Cup.
November 25th, 2025, 1:30 before Judge Kunke.
Does the court have any flexibility with that date, or should I take it up with Judge Kunke?
You're going to take it up with Judge Kunke.
Thank you, Your Honor. Can
Bond will continue.
I
Thank you.
approach to sign the information?
thank you, Your Honor.
Thank you. Court does call the case People versus Stephen Grisbeck. 3 cases.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Grisbeck.
Assistant Public Defender Chelsea Richfield with and on behalf of Stephen Grisbeck.
Your name? Stephen Griswold. Thank you.
Your Honor, asking the court to set these cases for.
And likewise on my cases.
So all discovery is complete on these matters.
Yes, Your Honor.
To the best of my knowledge, yes, Your Honor.
People have their witnesses available the 14th. I'll take that as a yes. Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Fleischer.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Let me get this. Court does call the case People versus Alicia Cargill.
Good morning, Rob J. Killen, Cargill. Cargill, would you state your name for the record? Judge, while we're waiting, just a brief history. I did see Ms. Cargill at the prison on August 20th. On September 12th and September 19th, I went to the prison. They could not find a computer to play the disc. They finally found one and called me. I went yesterday to see Ms. Cargill to play the disc. She refused to see me. So I'm not sure where we are in this matter, Judge.
State your name, please.
Alicia Cargill.
Thank you. All right. What would you like me to do with this matter?
Ms. Cargill, if I come out to see you to play the video, are you going to see me?
Yeah. At this point, I don't want an attorney.
You what?
I do not want an attorney. You're stating
At
things
all?
that are not true. You came up here and you were how late? So yeah, I was no longer at control center an hour after the time that was scheduled. You're right. But it's not that I refused to see you. I sat up here for an hour yesterday. You did not show up. You were late. Extremely late. So miss me with that. I don't want no attorney. I represent myself.
Ms. Cargill, hold on. So is it right now that you don't want an attorney at all? Or
yeah, at this point, I can represent myself. He still hasn't sent me my discovery. He came out here over a month ago. I asked for a discovery. I'm yet to receive any paperwork about this case at all. I don't know anything that's going on.
okay, so you want to represent yourself?
Yes.
Okay, I'd have to advise you that might not be advisable to represent yourself in this case. You are charged with the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years incarceration and or a $5,000 fine plus court costs. Do you understand all of that?
No, because when I got arraigned, that's not what I was charged with.
You understand also that if you do represent yourself, you will be held to the same standards as any attorney, that the court will not be assisting you in any way in your representation. You understand that, sir?
I do not want this attorney. So it doesn't, at the end of the day, and then you're sitting here telling me new charges that's not what I was arraigned under. I was arraigned under assault or whatever with less than whatever. Nothing with strangulation.
Sir,
this is news.
Ma'am,
so I'm confused.
That's the charge that I have before me. That's why I'm apprising you of what the charges are. You wish to represent yourself. I've told you that you will be held to the same standards. The court would also indicate that if at some time you wish to be to have the representation of counsel, you need to just request that of the court, and the court will oblige and make sure that you are represented by counsel. Do you understand all of that?
I understand everything you're saying.
Okay. So what do you wish for me to do today? Adjourn the matter so you can get discovery, or what do you want me to do?
I mean, I want my discovery I'm entitled to. I want to be represented properly if I'm going to be represented. I don't want to hear, I don't understand. So
Do you want me to adjourn the matter out so that you can get all that information and make your decision, or what do you want me to do?
I can't go in the breakout room with my attorney or anything? I'm confused. I don't get
I
this.
am not gonna do that, sir, ma'am.
Okay, well, I'm not I didn't consent to Zoom either, so I don't know what's going on.
Judge, I'm just for the record, I met, never mind, I'm not trying to get into argument. We went over the discovery. I was 10 minutes late yesterday. They could not find it or play my disc. That was the delay, Mr. Cargill. Now, I sat there for close to 45 minutes before they told me they had a computer to play your disc.
Well, I think you need to get the discovery to the person. I am going to find good cause to adjourn this proceeding since nobody will give me an answer of what they want to do. I will adjourn it 2 weeks out. I need 2 weeks for the writ in any event, so it's going to have to be October 16th, that following Thursday from the Tuesday. October 16th, 2025, 9 a.m. Bond continued. Thank you.
I'm sorry, I'm on vacation.
Well, wants to represent himself. I don't know what you guys are going to do. I'm setting it for that date. You can talk to each other, make your decision. If it looks like you are going to be representing this individual, Mr. Hillewald, then certainly you can seek an adjournment from the prosecutor to set a date. Thank you. Bond continue. Court calls case People versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Baum on behalf of the defendant. You should be joining us by Zoom.
Do you have him? Callejas? They are not present.
Would you mind passing this so I can call the client, Your Honor?
Yes, I would,
Thank you.
because I don't know why they're not here.
Me either.
Bench warrant will issue for defendant's failure to appear. Bond in each case will be set in the amount of $10,000 cash surety. Warrants will issue immediately. Thank you. Court calls case People versus Cedric Green.
Ready, Judge, Torshell Fleischer, Assistant Public Defender, on behalf of Mr. Green. On one file.
Morning. Good morning, Your Honor. Christina Costantino on behalf of Mr. Green in the other file.
She just appeared out of nowhere. She's so short, we didn't even see her. All right.
Magic.
Good morning. Your name, sir? Cedric Green. Thank you.
Thank you, Judge. I have spoken to Mr. Green. We have discussed his file that I have. I believe he still wants to preliminary on that file. I'm not sure what he wants to do on Mrs. Constantino's file.
Same, Judge. We would be asking for a preliminary exam date. Discovery is complete as to my knowledge.
Likewise.
I know.
I
I will let the judge know that.
People have their witnesses available the 14th.
I believe so, Your Honor.
Preliminary examination in person, October 14th, 2025, 9 a.m. These are will be set before Judge Valvo.
Thank you.
Bond will continue. Thank you.
And
I'm sure Mr.
Judge,
Green wants to address the bond.
Yes.
yes, Judge, he does wish for us to address his bond. He currently has a bond set that he cannot post. And the reason for that is due to a missed court date. I was told by my client as well as another attorney who was present the day of that court date that Mr. Green did appear in court that day. He was just late. He was on the 9 a.m. time block and he did appear at, I think, around noon. Is that correct, Mr. Green?
My bus got here like a. Are you
He's
aware of
indicated-
the Ann Arbor Police Department report bond violation?
No, Judge.
Oh, okay. Go ahead.
I
Judge,
join my colleague's bond motion, Judge.
Pardon?
Yes,
I have nothing additional to add. I'll join Ms. Constantino's bond motion.
Judge, we just want you to know he did appear in court that day. His bus was running late. That was the reason he was late to court. He did appear physically that day. But for the warrant being issued that day, he would have been out on his own recognizance. Sorry, what?
I have a bond violation, a conditional bond violation, at least police report. His missed appearance was on September 11th. He had police contact on September 20th, which is, I do believe, what then brought him into custody. From the 11th, he did not do anything to appear before the court. So for those reasons, his the request for bond modification or reduction is denied. Bond will continue as is.
Thank you, Judge.
Thank you.
Thank you, Judge.
Court calls case People versus Randall Jolly. I'm not even going to begin this plea. Do I have an advice of rights form?
You should. We filled it out, put it in the file.
They're going to need to do it that day. I'm not going to sit at ground. Go ahead. What are we doing?
Your Honor, we are offering a plea if the court will accept it.
I have before me the plea form that indicates that the defendant will be pleading guilty to the charge of use of amphetamines, that being Adderall, first offense, the 1 year charge. That upon his successful plea to that charge, counts 1 and 2 would be dismissed. There is a sentence agreement. Well, it indicates here defendant is not eligible for 7411 treatment. That's the court's full understanding of the agreement.
It is ours as well, Your Honor.
That's correct.
May I have him sworn?
Raise the right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Randall Jolly.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of an amphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes, sir.
And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 1483 District Court.
Understand.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did, yeah.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you're guilty?
Yes.
July 2nd, 2024, I-94 near M52 in Sylvan Township, Washtenaw County, state of Michigan. Did you have Adderall in your possession?
Yes, Your Honor.
Did you have a current prescription for that?
No, sir.
Did you know what you had in your possession was Adderall?
Yes.
And had you used it?
Yes.
Sir, I do have to advise you that if the court does accept your plea, that if you commit misconduct between the time that I do accept your plea and the time of sentencing, any sentence agreement evaluation by the court would no longer be bound by, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
There are none.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, the people are satisfied.
Satisfied, Judge.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
November 3rd at 9 a.m.
November 3rd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you, sir.
Does my client report to probation in this today?
He can go right down to probation and they'll take care of it.
Thank you.
Court calls case People versus Dustin Duncan.
Assistant Public Defender Ben Dunaway on behalf of Mr. Duncan, who is approaching the podium now. Mr. Duncan, would you state your name for the record, please?
Dustin Duncan.
Thank you.
And Your Honor, defense would like an exam date.
Discovery complete.
Yes, Your Honor.
People have their witnesses available the 14th.
I believe so, Your Honor.
Preliminary examination will be set in person October 14th, 2025, 9 a.m. before Judge Washington.
Thank you.
Bond continued. Thank you.
No, you.
Court calls case of the People versus Cameron Baker.
Good morning, Your Honor. Daniel Schumann appearing on behalf of Mr. Baker.
State your name, sir.
My name is Cameron Baker, Your Honor.
Thank you. All right, what are we doing?
Your Honor, we've been recently retained on the matter, did receive discovery. I believe it's complete, but we just received it. I'm looking for an opportunity to further discuss this matter with my client and the prosecution. May we adjourn the exam to October 16th? The PCC, I'm sorry.
Without objection, October 16th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Robin Finney.
Andrew Vanish with People.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Robin Finney, who's approaching to my right. Can you state your full name for the record, please?
Yes, Robin Lee Finney.
Thank you.
Your Honor, at this time, we're going to be requesting an adjournment. My client is waiting to get into Bear River. She's on the wait list.
For release to inpatient.
Yes. So we would ask for about at least a month adjournment at this point.
She held on anything else or just this case?
Just this case.
I mean, I'll grant that, but. October 30. October 30th. She is, thank you, that's fine. I'll take that representation. Probable cause, October 30th, 2025, 9 a.m. Bond continued. Thank you, Ms. Frank. You got to keep moving. Court calls case People versus Brock Gerard.
Ready, Your Honor. Okay, well, all right. Good morning again, Your Honor. Stephen Moss on behalf of the defendant, Brock Gerard, who is now standing to my left. Identify yourself, please.
Brock Gerard. Flip.
Which sides?
I'm left.
Take that out here.
Yeah, I knew that. Good morning again, Judge. Today is the date and time scheduled for a probable cause conference. Mr. Gerard will waive his right to a preliminary exam today. He has executed the written waiver. You should have that in your file.
You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and you committed them?
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
We do.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. As to the circuit court arraignment, you acknowledge receipt of the information, waive its reading.
So acknowledge waiver reading of the information, Your Honor.
And how does your client plead at this time?
Please not guilty.
Defendant having waived formal reading, pleading not guilty to all 3 counts, court will enter that plea. Pre-trial will be set for
December 3rd at 1:30.
December 3rd, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case People versus Robert Gallet or Gallup.
Morning, I'm Robert. Oh, well, Judge, I'm on case 25F5 5612.
Assistant Public Defender Elsie Vergil is with and on behalf of Robert Gallet.
State your name, please.
Robert Gallet, also known as Lynn, sir.
Thank you.
You're very welcome.
What are we doing?
I believe we'd like to set a preliminary exam in both cases.
Correct. Discovery complete in both cases?
Yes, Your Honor.
Yes, Your Honor. Can we send my office to the information?
People have their witnesses available on the 14th or 16th. No, 14th, I'm sorry.
I believe so, Your Honor.
Judge, can we go the next week? I'm sorry, I'm on my first vacation.
Are you held on anything else?
Yes. I believe Ms. Gallet is being held. So the case that I have her with is a $10,000 bond, which is holding her $100 on Mr. Kilowald's case and then $100 on a misdemeanor in 15th District Court.
Bottom line, is there any objection to going to the 21st?
No, Your Honor.
Thank you, Judge.
Preliminary examination in person, October 21st, 2025, 9 a.m. That is before. Is that noon? Can be.
At 9 a.m. 9 a.m.
Is it before me?
Yes.
9 a.m. before me. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Thanks, Judge.
Court calls case People versus Donovan Friel.
Good morning, Your Honor. Samuel Bennett, bring with and on behalf of Mr. Friel, who's appearing via Zoom. We waive our in-person appearance.
Friel,
Yes, sir.
state your name, please.
Donovan James Friel.
Thank you. What are we doing?
Your Honor, I'm just looking if we can set an exam date for that 14th of November. That would be perfect, please.
Well, is discovery complete?
Yes.
People have their witnesses available the 14th.
We'll do our best, Your Honor.
Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Valvo. Bond
you very
will
much, Your Honor.
continue. That is in person. Bond will
Absolutely. Thank
continue.
you, Your Honor. Have a good day.
Thank you. Court calls the case, People versus Richard Halstead.
Andrew Banis for the people.
Mr. Byrd? No, it's okay. Sorry to wake you from your nap.
Brandon Byrd on behalf of Richard Halstead.
Thank you. Your name, sir?
Richard Halstead.
Thank you. What are we doing?
Respectfully, Your Honor. We were trying to work out a deal last time. I just asked for a slight adjournment if possible.
Probable cause conference will be adjourned to October 9th.
And permission to address bond to you.
Briefly. 9 a.m. That's at 9 a.m. Yes.
Respectfully, Your Honor, my client was in contact with me last time. Truck went down when he was trying to get here. He did try and contact me. You gave him a 48-hour warrant, but he contacted me a little bit later than after that 48 hours. But I'm just asking.
How did he come back into custody?
Let's be back in.
Last Tuesday.
Pardon?
Last Tuesday, I turned myself in.
Why didn't he appear?
His truck went down, Your Honor. When he tried to when he tried to get here.
Any response from the people?
Your Honor, we'll leave it to you. I do not have any thoughts.
Previous bond is reinstated.
All right. Reinstated.
I'm sorry.
Fine.
Motion is granted. Court does call the case of the people versus Brandon Kelly.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kelly.
Mr. Kelly, can you state your name, please?
Brandon Kelly.
Thank you. What are we doing?
Mike Gaddy for Mr. Kelly, Your Honor. Your Honor, having a chance to discuss this matter with Mr. Chablowski and with Mr. Kelly, I think we want to set this for an exam today.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 14th. Preliminary.
90 days in jail for one punch. That's how long I've been in here.
All righty then. October 14th, 2025, 9 a.m. That's before judge, and the record should, well, he hasn't left the room. Record before who?
Washington.
Judge Washington. Bond will continue. Court calls case people versus Gavin Porter.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Porter. You state your name? Gavin Porter, Your Honor. Your Honor,
so go ahead.
I completed a green sheet. I would be requesting an adjournment so that retained counsel can
finally give us an appearance or a substitution.
That's correct, Your Honor.
My office is notified twice what he needs, and it's inexcusable that he doesn't have it.
And
probable cause conference will be adjourned to October 16th, 2025, 9 a.m. Bond continued.
Here, it's okay. Thank you. Thank you.
Court does call the cases of the people versus Montel Gatlin.
Assistant Public Defender, Tanaka Ruby, Your Honor, on behalf of Mr. Montel Gatlin, who is approaching. Today is the date and time set for competency evaluation. I have receipt of the report. Does the court have it?
What's the date of the report?
I apologize, Your Sorry, Judge, I have to pull it out.
Do the people have a copy of the report?
No.
So that's true.
Oh, sorry, Judge. Actually, I apologize. I do. It was mislabeled. September 12th.
It sounds proper.
And wow, with you or no?
Well, the last report I have is July 12th. It's gonna have to be emailed over. We're gonna have to take it back because
Okay.
I'll have to review the report. Somebody get me a copy. I'll look at it and we'll
I'll
send
send
it
it
back
right
out. All right, Mr. Gatlin. Court does call the case of the people versus Jacob Ramsey.
Andrew Banish for the.
Morning, Your Honor. David Chan, on behalf of Jacob Ramsey, who's approaching.
Your name, sir?
Jacob Ramsey.
Thank you.
Your Honor, we're going to waive the preliminary examination.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes.
You understand that it's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir. That's Your Honor.
People also waive their right
Yes.
Preliminary examination, having been waived, defendants bound over to circuit court on a single count. Mr. Shand.
We will waive formal reading of the charges. Defendant will stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
November 25th at 1:30 with Judge Company.
November 25th, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Thank you. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Emmanuel Hunt.
Analyst on behalf of the people, Your Honor.
Yes, now, Bird on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Angela Julius Hunt.
Your Honor, we'd like to set this matter for exam.
Do you also want a hearing on this bond violation?
No, Your Honor.
He admits to it.
He admits to it.
How long has he been in?
Almost 30 days now, Your Honor.
And his arraignment date is 9/7.
Gotcha. Sentence on his bond violation is 14 days, credit 14, sir. Discovery is complete. I'm sorry, counsel.
As far as I know, Your Honor.
People have their witnesses available the 14th.
We'll do our best, Your Honor.
You need to do me a favor on that.
Yeah.
Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Valvo.
Thank you, Your Honor.
Thank you.
You, Your Honor, the court have a great.
The same, sir. Be well.
Thanks.
Court calls the case People versus Nicholas Smith.
Alex Jablowski, the people.
Okay, good morning, Your Honor. Robin Kennedy appearing on behalf of Mr. Smith, and I am going to turn my video on here in just a moment. There we go. Thank you.
Thank you. Mr. Smith, can you state your name, please?
Yes, sir. Nicholas Smith.
All right, what are we doing?
Your Honor, Mr. Smith has the opportunity to avail himself of a reduction, but in order to do so, we are seeking out treatment courts, and he is not in Washtenaw County any longer. So we are searching for treatment courts. We're asking hopefully for just a last adjournment to have the application processes complete and to have an answer as to whether or not he would potentially be accepted into a program that would be local to him.
Not objection, probable cause conference, October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Marcus Jackson.
Andrew Banish.
Assistant Public Defender Davey Lieb on behalf of Mr. Jackson. Your Honor, Mr. Goldstein has filed a substitution in this matter, and I believe he has stepped out. So I would request.
Where?
Judge Washington.
Do you have it?
It is in my file, Your Honor.
What?
I have a copy in my file, Your Honor. I don't know if.
Okay, that does me no good. Is it signed by me?
No, Your Honor.
We got it?
Yeah.
So it's Goldstein's case. Do we know what he's doing? He's not here. All right, I'll pass. I'll pass it. I'll have to call him out later. Court calls case People versus Terrence Smith.
Alex Jablowski, the people.
That order is for Terrence Smith. I should be on Zoom, Your Honor.
Terrence Smith.
I'm here.
State your name.
Smith.
All right, I'm asking for an adjournment. I believe we were close to a resolution. We just gotta facilitate a form.
October 9th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Mohammed Farah. AG's in jail.
I'm acting on behalf of Mr. Farhat, who's to my right. Please state your name for the record.
Mohammed Farah.
Christina Bate on behalf of the AG's office.
Thank you. All right, what are we doing on this case?
Your Honor, this time we are waiving to circuit court.
All right. Sir, you're waiving your right to preliminary examination. Yes, sir. You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further proceedings.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
May I?
Your turn.
Oh, Your Honor, we waive formal reading.
And how does he plead? Defendant having waived formal reading, standing mute, court will enter not guilty plea as to both counts. Pre-trial in this matter will be set for
October 15th at 1:30.
October 15th, 2025, 1:30 before Judge Conlon. And I'm sure the circuit court has how it's going to deal with dealing with these cases in the event of shutdown, but that's the best date I have. All right.
Your Honor, may I just bond?
Yes, you may.
Your Honor, my client indicates that he does have a spot at Avalon Housing, and that spot will go away if he stays here. And also, he's been working in front of the court to secure employment, and he was able to with Michigan Works. So we ask that he be pleased.
You're asking that it be reduced. I don't need a response. He came in and he certainly turned himself in. And I arraigned him. I set the bond. I set it at the 25%. I don't have a justification for going lower than that, although those are all admirable facts. I don't think that constitutes justification or good cause to go lower. So it's set as low as I'm going to do it.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Joseph Fittler.
Good morning, Your Honor. Lawrence Margolis with and on behalf of Mr. Spittler. To my right, Joseph, please state your name for the court.
Joseph Spittler.
Your Honor, we are still in negotiations and Mr. Kennedy has asked for a 2-week adjournment. No objection on my end.
Probable cause conference, October 16, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court does call the case of the cases of the People versus Daryl Frederick.
Senator Chelsea deals with on behalf of Daryl Frederick. Mr. Frederick, please state your name.
Daryl Frederick.
Your Honor, we are asking to adjourn cases for discovery.
I'm sorry.
We're asking to adjourn for
What was going on?
here so our office can get information regarding cases.
Probable cause conference will be set October 9th, 2025, 9 a.m. Bond continued.
Your Honor, may I address bond?
Yes.
Your Honor, we are just asking the court to consider allowing a release to treatment. Mr.
If you
Frederick.
file the order for release to treatment, I'll sign it.
All right, thank you, Your Honor.
Court does call the case of the People versus Condra Weathers.
Excuse me, Andrew Bannister.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Weathers, who appears by Zoom.
Weathers, state your name, please.
Hey, Andrew Weathers.
Thank you.
We're just awaiting a yes or no on a resolution from the prosecution, Your Honor.
They have it in 9 days or they need more time. It didn't sound confident. October 16th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Court calls case people versus Isaiah Max Stewart. That's a
Alex
key.
Jablowski for the people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Max Stewart, who stands to my right. So would you state your name for the record, please?
Hezekiah Max Stewart.
And Your Honor, we would like to set this for exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 14th. Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Washington.
Thank you,
Bond
Judge.
will continue. Thank you. Court does call the case People versus Sean Beater.
Andrew Van for the people.
Ms. Apple,
I'm sorry, Judge. What did we?
Sean Beater.
Oh, I apologize.
It's all right.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Peter.
Sir, can you state your name, please?
Sean Vitter.
Thank
Thank
you.
you.
Your Honor, we're asking for an adjournment for some plea negotiations.
All right. Is this the only thing that's holding him or is he held on something else?
I believe he has some nominal cash bonds out of a district court that are also holding him.
All right.
So we're trying to see if maybe a treatment court might be an option for him.
A treatment. So you want
Mental health.
the 9th or 16th?
If we could go to the 16th, so I can at
16th.
least have an update on that.
Probable cause conference will be adjourned October 16th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, sir.
Have a nice day.
Court calls case People versus Jason Maples.
Thank you. On the Constable Basin on behalf of Mr. Maples. Mr. Maples, can you state your full name for the record, please?
Jason Gary Maples.
What are we doing?
Your Honor, at this time, my client is wanting to waive on both cases.
Is that correct, sir?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on the single count in each case. Mr. Robinson.
Thank you, Your Honor. We acknowledge receipt of the information. We waive any formal reading, standing you to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for
October 21st at 1:30.
October 21st. You said October 21st, 2025, 1:30 before Judge Funky.
Thank you, Your Honor.
Bond will continue. Court calls case.
Anna Mackey on behalf of Mrs. Baird, who is approaching.
Her name.
Kayla Baird.
What are we doing?
Your Honor, we are adjourning this matter. We do have but we did not submit the form in time.
We also have a bond violation. Not tested or gone back for testing.
Your Honor, I think there was some miscommunication with my client and reporting for testing. She was under the impression that she had to wait for notification that she'd be able to test in Flint. I think at the last PCC, we discussed that that's a possibility.
She indicated she would check out someplace close to where she was staying to test and get back to community corrections. She's not gotten back to community corrections, not called them back, not indicated anything. Neither has counsel.
Would she be able to
So
test
the
today, Your
problem
Honor?
is that since that time, she's missed 2 tests.
Is there,
She's got to test or get us a place to test.
she is currently not working, Your Honor, and doesn't have the funds for transportation or test. Would she be able to test today?
Does she have the funds today?
I can get the funds. Yeah.
Pardon?
I can get the funds.
I don't know what that means. Does she have the funds?
Yeah.
Someone's here with her, Your Honor. And we'll give.
Okay, all that tells me is somebody's here with her. Does she have the funds
They will give
to
her the
test?
funds to test, yes.
Get over to community corrections, test now. Come back. Are you gonna test clean?
Yeah, THC.
Do you have a card?
No, I have.
Defendant's bond revoked, defendant's remand.
Thank you, Your Honor.
I will adjourn her probable cause conference to the 9th, 2025, 9 a.m. bond continued. Or bond revoked, excuse me. Court calls the case, People versus Jeffrey McCullough.
Alex Warren Green on behalf of Mr. McCullough in the case ending 0980.
Witness. Quinn? At the bottom.
Christopher Quinn appearing on behalf of Mr. McCullough.
Your name, sir?
Jeff McCullough.
Thank you. What are we doing?
Your Honor, I am requesting an adjournment in my case for further investigation.
And Mr. Quinn, what are we doing on yours?
I believe mine was set for an exam, Judge. We can go ahead and set it for exam.
You're ready? You got all discovery?
Yes.
People have their witnesses available the 14th.
I believe so, Your Honor. Thank you.
In the matter ending in, I think, 0098. Preliminary examination in that matter will be set in person October 14th, 2025, 9 a.m. before Judge Valvo.
Okay, thank you.
And in that matter, bond will continue. You're seeking an adjournment in the other matter.
That's right, Your Honor.
Probable cause conference in that case will be adjourned October 16th, 2025, 9 a.m. Bond continue. Court does call the case People versus Edward Casto.
And Alex Warren Green on behalf of Mr. Casto.
Oh, Your Honor.
You state your name?
Edward Casto.
It's the best pants you could find.
I got it. It's I'm going to school, HVAC. So right after this.
Your Honor, I'm requesting an adjournment so that we can obtain media discovery in this case.
Oh, discovery.
Yes.
Oh,
And
I said and pants.
I'll make
Okay.
sure he has them next time.
Probable cause conference will be adjourned October 16th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court calls the case People versus Sean Newcomb.
Alex Chappellowski, the People.
Adam Mackey on behalf of Mr. Newcomb, who is to my right. Please state your name for the record.
Sean Newcomb.
All right, what are we doing?
Your Honor, at this time, we are waiving the matter to circuit court.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed in.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we acknowledge receipt of information, we waive formal reading, and my client will stand mute.
Defendant every way, formal reading, standing mute. Court will enter not guilty plea. Pre-trial in this matter will be set for October 15th, 2025, 1:30 before Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Tristan Clay Radcliffe.
Your Honor, Assistant Public Defender Carson Dulace on behalf of Mr. Tristan Clay Radcliffe, who is present to my right. Can you state your full name for the record, Mr. Radcliffe?
Tristan Clay Radcliffe.
I have a plea form that indicates that he's going to be pleading guilty to the charge of embezzlement from a vulnerable adult, 200 to 1,000, the 1-year offense. That's a count 3. Upon his successful plea to count 3, counts 1 and 2 would be dismissed. Defendant also is agreeing to pay $812 restitution.
That was already paid.
Has it already been paid?
Yes, that's correct, Your Honor.
Yes. All right. Mr. Babisi, I'll need you to check the box that you didn't check on that form and initial.
There's that place of rights.
May I have him sworn?
Raise your right hand. You solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Tristan Clay Radcliffe.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement from a vulnerable adult. That is a misdemeanor. Or 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced by Judge Fleischer in the 1483 District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of December 23rd, 2024 and December 30th, 2024, at the location of 8633 Main Street, Northfield Township, Washtenaw County, State of Michigan, what did you do that makes you think that you're guilty of this offense?
I took money from Ronald Bolzman.
Pardon?
I took money from Ronald Bolzman.
Okay, and was there anything unique about Mr. Holzman? What was your relationship to them?
He is a vulnerable adult. He cannot use his arms.
Okay, so he's a paraplegic?
Yes, sir.
In a certain respect?
Yes,
Is
Your
that
Honor.
correct?
Yes, Your Honor.
And you took his, and why were you in proximity to this person? Were you a caregiver?
I worked there.
You worked there
I did
and
previously.
you took a financial transaction device
Yes, Your Honor.
and then used it to the extent of at least $200. Is that correct?
Yes, Your Honor.
All right. And you didn't have his permission to do that, did you?
I did not, Your Honor.
Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing, any sentence evaluation the court would no longer be bound by, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor, just for the record, my client is looking to be sentenced under HIDA when the time is appropriate. So
Would like to, I'm sorry?
my client is seeking to be sentenced under HIDA when when the sentencing
Is
is up.
there a reason it's not on the form?
It wasn't a sentencing agreement, Judge. I think Mr. Delvazy is just informing the court of the defendant's intentions.
All right. Sir, you understand that that's not any type of promise in this case?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be November 3rd, 2025, 9 a.m. before Judge Fleischer. Bond will continue. Thank you. Court does call the case, People versus Antoine Pitts. Where is Goldstein in an exam?
What city?
Because this is the second one that we. Yeah. Mr. Delvazy, do you see Mr. Goldstein in the hallway?
I think he's next door, Josh.
And when were you last next door? Never mind.
I am certain Paul is in Old Vegas, but I don't know how you're.
Is he next door? We've lost Goldstein. Sir, I'm gonna have you taken back. We're looking for Mr. Goldstein. He appeared. I have another case and then he went wherever. So if we can get him here, we'll take care of it. Court does call the case of the People versus Malik Cleveland.
Andrew Bannister.
Stephanie Cannon on behalf of Mr. Cleveland, who's appearing to my right. Mr. Cleveland, could you please state your name for the record?
Malik Cleveland. Wow. First case. She's here. This is a miracle. And yes, I see that.
Yes.
I filed charges too. Go ahead.
Your Honor, we're asking for an adjournment of this case for mitigation. My client has provided me with a lot of information. I just needed to get over to the prosecutor's office.
All right, how much time will that take? Can you get it done by the 16th?
Yes, Your Honor, absolutely. Oh, Your Honor, you already gave him permission to go out of town for the 16th.
I did.
Yes, we did it.
Where's he going?
This is,
I'm taking a cruise trip, first time out of the country, to New Orleans and Mexico.
I gave him permission to do that?
yes.
I have.
That's what. Thank you. Right. Whatever, yes. So, Your Honor, an offer has been extended.
Oh, you did it in order.
Yeah, and I just informed Ms. Cannon that there were three co-defendants, and I'm making the same offer to all three. Unfortunately, Ms. Cannon and I didn't discuss that yet, so maybe we could even have a very short adjournment to see if we could resolve it.
Absolutely, Your Honor.
You two decide?
No, Your Honor, we are pontificating over certain subject matters, but we're just relying on your judgment.
Slowly back. I'm requesting the next available date to see if we can resolve this.
Thank you for clarifying that, Mr. Banish. We're good. Probable cause conference, October 9th, 2025, 9 a.m. Bond continued.
Perfect, Your Honor. Thank you so much.
I know, I did it.
Perfect.
All right. Court calls the case, People versus Jeremiah Sawyer.
Alex Jabberwocky for People.
Hannah Mackey on behalf of Mr. Sawyer, who is approaching.
Anybody sees Goldstein, tie him down when he gets in. Your name, sir?
Jeremiah Sawyer.
Thank you.
Your Honor, we'd like to set this matter for exam and all discovery is complete as far as we are aware.
Would the people have their witnesses available on the 14th?
Yes.
Preliminary examination in person will be set October 14th, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond will continue. Court does call the case of the people versus Dario Gardner.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Ben Menowith on behalf of Mr. Gardner, who is joining me at the podium now. Sir, would you state your name for the record, please?
Dario Gardner. Thank you.
And Your Honor, we would like to set this for exam.
Is discovery complete?
Yes, Your Honor.
People have their witnesses available the 14th.
We'll do our best, Your Honor.
Okay, come back to
Preliminary examination in person, October 14th, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you, sir. Court does call the case of the people versus D'Angelo Simmons.
Hannah Mackey on behalf of Mr. Simmons, who is to my right.
Your name?
D'Angelo Simmons.
Thank you.
Your Honor, requesting to adjourn this matter. It looks like our office has not received the discovery yet.
Discovery on its way, or what's the deal? Pardon?
I will look into that right now.
All right. I'll grant the adjournment. Probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the cases of the people versus Antonio Young.
Alexander, on behalf of the people.
Hannah Mackey on behalf of Mr. Young on.
Out of the way, Constantino. Oh, so you're canceled. Never mind. My bad.
Needed to get here.
Huh?
Christina Costantino appearing with and on behalf of Mr. Young in case number ending in 1177.
It was Cannon that was in the way. I figured it couldn't be Constantino. It had to be Cannon. Cannon was in the way. She was blocking him. Is that what the deal was? Okay, thank you for noticing that. We'll take care of
Appreciate
that.
it,
Sir, your name? Antonio Young. Thank you.
Judges, is the date and time set for PCC. We are asking for an adjournment of the PCC. We are attempting to work out a global resolution of all of Mr. Young's matters.
16th, will that work?
Yes, Judge.
Probable cause conference, October 16th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you.
Thank you.
Court does call the case of the people versus Vinnie Sims. Yeah, here we go. Okay.
Assistant Public Defender Chelsea Regiles with and on behalf of Benny Sims. Mr. Sims, please state your name.
Benny Allen Sims Jr.
Your Honor, Mr. Sims would like to waive his right to a preliminary exam. I'm here to do that.
So you're waiving your right to preliminary examination?
Yes, sir.
And you understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Ms. Regiles.
We acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for
October 20th at 1:30 with Judge Fleischer.
October 20th, 2025, 1:30 before Judge Hamud.
This is so our press can get information.
Bond will continue. Thank you.
The biggest part is that.
This is Mr. Mesa's initial announcement. I spoke with him a few minutes ago as he's in the process of hiring his attorneys. So if we give him a few weeks, that's another on board.
For the court is Ms. Brown, represented by Mr. Washington, and we have Mr. Pugh from the prosecutor's office. We are here today for a final probation violation. Mr. Washington, does your client wish to have a contested hearing in this matter?
No, Judge.
Ms. Brown, do you understand the rights you're giving up by admitting to this violation?
Yes.
Is this what you want to do?
Yes.
Do you admit or do you deny that you violated the terms of your supervision?
Yes.
Based upon your admission, I find you have violated the terms of your supervision. We have 54 days of jail time credit. Is that right?
That's correct.
Mr. Pugh, on behalf of the state.
Your Honor, my understanding is that at the time of sentencing, the court placed Ms. Brown on non-reporting probation with the intent and told her at that time if she was convicted of new theft offenses or had not paid restitution, that he was going to, court intended to sentence her to 12 months in prison. As the court's aware, she's had 9 new theft convictions since that 2023. The state recommends that the court follow through with a statement as made at sentencing and sentence her to the 12 months on a revocation of her probation.
Sufficient, anything from probation?
Nothing further, Your Honor.
Mr. Washington?
Judge, certainly she understands the wrongfulness of her actions. I think this is an opportunity for her to get this behind her and get this conduct behind her. She's 40 years old. I know that she wants to try to do things the right way. And I think her way got very, very cloudy at points, but she's accepting responsibility. We ask the court to impose the appropriate sentence.
Ms. Brown, what do you want to tell me?
I'm not gonna say.
I have to tell you, Ms. Brown, when you and I had this discussion back in November of 2023 about you not getting a new theft offense, I had no idea that you would pick up 9 new criminal theft offenses. That is very disturbing to me, that you would be on probation, not to mention the fact that you had a ton of priors before you got to me. I do not think it makes sense to continue to supervise you on probation. I am going to impose a prison term of 12 months in prison. This includes an optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the sentence that you receive for the new felony. I'm going to give you credit for the 54 days that you have already done. I note that restitution was paid back in February of 2025. So what that means, Ms. Brown, is when you get to the institution, they have a whole bunch of ways that you can get out early. Transitional control, early release, 90-day, something. They're all administrative ways that you can sign on to mandatory post-release control, get out early. Sometimes they send me a letter asking me if I'm okay with it. There's only been twice that I've ever said no to that. I told those people in advance that I was going to say no. You are not among those people. So if you want to make a deal with the Department of Rehabilitation and Corrections to sign on for supervision and get out early, I don't think they ask me anymore on an F5, but they just go ahead and do it. But I'm not going to grant you judicial release, so it doesn't make sense for you to ask.
Okay.
Anything else? All right. Good luck to you, Ms. Brown.
Thanks, Judge.
Did you know on Smith, we're resetting that in 3 weeks for another pre-trial? Case of the state of Ohio versus Jonathan Butts, case number 25 CR 42662, present before the court is Mr. Butts, right?
Actually, that's not him. I'm going to go see if he's in the hallway.
Oh, okay.
I know he's here.
I believe he's still in pretrial trying to test.
Oh,
Would you like to sit down
yes. Oh, I didn't realize that.
Oh. This is cause number 24 CR 771. Hold on, John breaks everything in the room.
Anyway, we'd break our toys. So that they meant to.
If you give him just a little bit of time, he can do more damage.
I can figure everything out.
All right, in this case, you were Henry Mesa?
Yes.
Okay. You were charged with operating a motor vehicle in a public place while intoxicated, DWI. And that's on or about January 27th, a year and a half ago. Wow. It took forever to get to you, didn't it?
Yeah, I didn't even know there was a.
This was indicted.
To seal the record. So, Mr. Cox, we continue this out a little bit. It was my understanding we were going to get some progress on the
payments. Yeah. So I ended up getting a place for rent, but I was moving stuff in last month and I fell and sprained my ankle and fractured my fibula. So I just got cleared yesterday to get back to work. So I was going to see if maybe I could get another 30-day extension to try to
make it easy on yourself. If you want 30, if you want 60, this is your motion. Mr. Harris is in no hurry to get this resolved. So you tell us when you want to come back.
We go 60 probably be better, but I'll probably be able to pay more on it. But like I said, I fell, got pretty tore up. So I've been out of work for the past 3 weeks and it kind of set me back.
Okay. Ms. Groko, can we go ahead and get Mr. Cox a date? And
I wanted to apologize for that too, because you guys already gave me 90 days, but
yeah. And can we make sure that, do you have that case up?
Yes.
Can we make sure that Ms. Idle did not process the denial? All right, we'll get you a date.
all right.
She's so efficient these days. This is the case of the state of Ohio versus Jonathan Butts, case number 25 CR 42662. Present before the court is Mr. Butts, right?
Yes.
Represented by Mr. Washington. We have Mr. Harris from the prosecutor's office and Officer Kell from probation. We're here today for a hearing on the ILC request. We do have a preliminary matter. We have a motion to amend the indictment to include an H in the Jonathan. Well, another H. JOHNATHAN is the proper spelling of your name, right?
Yes.
No objection to the motion to amend the indictment?
No objection, Judge.
All right, court finds that there is no substantive amendment other than the addition of an additional H to the name. And I'll go ahead and sign that order now. With regard to the substance, we're here today, Mr. Butts, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge, but instead of finding you guilty and imposing a sentence, we're going to accept your plea of guilty, order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient treatment. You're going to follow the rules. You're You're going to do the theft class. You're going to pay the restitution in the amount of $11,954.69. That'll be joint and several. We'll talk about that in a minute. As long as you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol, which includes marijuana, during the treatment period, I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes,
How old are you?
28.
How far did you go in school?
I got an associate's degree at University of Michigan.
Are you able to read and write English?
Yes.
Are you under the influence? I didn't ask you that because it was Michigan. I ask everybody that.
Oh, yeah.
Are you under the influence of any medications?
No.
Other than what we have discussed today? Oh, are you a United States citizen?
Yeah.
Other than what we've discussed today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Washington before you signed it?
Yes.
Are you satisfied with the representation that you have received in the case?
Yes.
You're going to enter a plea of guilty to one count of theft. That's a fourth degree felony, punishable by up to 18 months in prison and a $5,000 fine. There is a presumption that even if you don't successfully complete the ILC, that I would not send you to prison. But if I do, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about December 29th, 2024 through January 27th of 2025, this is in the city of Monroe, Warren County, Ohio, the defendant, Jonathan Butts, along with his co-defendant, Donovan Mann, processed fraudulent returns at their employer, which was Brooks Brothers, in the amount of $11,954.69.
Anything on those facts, Mr. Washington?
Nothing on those facts.
Did you hear those facts, Mr. Butts?
Yes.
Do you admit that they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes.
Which plea?
I was guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Theft class, no more weed, outpatient treatment. Anything else regarding the treatment plan? All right. I'm going to grant the motion for intervention in lieu of conviction. These proceedings are going to be stayed for a period of 3 years. I am going to order restitution in the amount of $11,954.69. Brooks Brothers. That is going to be joint and several. That means that each of you owe that entire amount. Although what I envision in this case, Mr. Butts, I told this to your co-defendant yesterday with Mr. Mann, I anticipate that each of you are going to pay your own half of this. And if you do, I'll probably let you off supervision after a year, as long as you can behave yourself. How long before you can give me a clean urine screen?
I'm waiting to take it right now.
All right, are we going to pass today or what?
Yeah.
All right. If we don't have a clean urine screen within, let's call it 45 days, I want you to file a out of custody. Doesn't need to go to jail for that, but ILC and marijuana are fundamentally inconsistent with one another. So we're going to adopt the treatment plan, follow the rules. Hopefully you and I don't see each other anymore. Anything else?
There you are. No, Judge, and I'll take the check to the clerk's office.
Yep.
Okay.
You can tell them if they ask that the restitution order has been filed.
Okay. Great. Judge, thank you.
We'll file Carl's paperwork for him.
That's the copy I have. That's the.
year and a half ago. Wow. Well, but you were arrested, right? You knew that. You knew something was going to come along.
I got out of Jasper County. And then that's when I came over here to figure this one out.
All right. The problem you have is anytime there's a DWI, it's a felony from here on. Because you have a DWI conviction in Montgomery County in 2017, another one in 2019, and another one out of Harris County. So it only takes 2 prior convictions of the DWI to turn any DWI into a 3rd-degree felony, which carries with it up to 10 years in prison. But this is your 4th one, not your 3rd one. Now, a couple of things. Do you still operate a motor vehicle?
No.
Well, you cannot operate a motor vehicle without an interlock device.
No.
If you get caught doing it, I'll pull your bond and you'll sit it out in jail until we get this thing finished.
Yes,
because I'm not going to let you drive around in a 4,000-pound missile without the appropriate safeguards, because you're being charged with the 4th DWI. Are there any other issues we ought to be dealing with to help you control your alcohol issues?
No, not right now.
Oh, you got it under control?
I wouldn't say I have been.
What are you doing about it? That's what's important. I want to know.
I just started a new job. I'm trying to just stay straight and try to get all my legal.
What are you doing about it? Yeah, I'm sure you've always intended to follow the rules, but this is the 4th time you've been charged with a crime. What are you doing to make sure that you're not going to get in trouble again on something like this?
Well, abstinence, because I'm on
abstinence.
I'm on probation anyway from just.
Okay, is it a felony probation?
Yes.
When did you get that?
That was
a few months ago.
Yeah.
So it's worse than we thought.
Well, that one wasn't an alcohol charge.
What were you charged with?
A handgun.
Sir?
Possession of a handgun. No.
Okay. So what did they charge you with? Unlawfully carrying a weapon or felon in possession of a firearm?
Unlawful.
Because
no.
You've been. So that's just a UCW, a Class A misdemeanor?
Yeah. No, it's a felony.
It's a felony?
It must have been unlawful by a felon then.
Yeah, that's what it is, because you've been, looks like you got 2 felony convictions in 2019 of DWIs out of Harris County and Montgomery County. So if you carry a firearm, even if it's in a moving vehicle, it's a felony for you. So you got to be careful for that. All right. So Mr. Dusler has been representing you, but you want some time to go hire your own lawyer. Is that what you want to do?
Yes.
Where do you work?
I work at ELM machining.
Oh, okay. How much do you make an hour?
I'm 32 right now.
Yeah. That's a fortune for a lot of people. Are you still at 1120 Red Bluff?
No.
All right. We need to know where you are now.
Okay.
Where? Pulling it out of you there.
I gotta get the address.
You don't know the address of where you live?
8631 Baker.
Hold on. Did you just move there recently?
Yes, when I got out of Jasper County.
Where's Baker?
Baker Street, Santa Fe, Texas. 77571, actually.
You think it's 77571?
Yeah, 570, something like that. I'm not too sure about the code. The address is right.
Okay, it's a 1 or a 0 is the last digit in the zip code?
Yes.
You don't know which one?
I'm not sure. I can look it up on my phone.
Yeah, go ahead. Yeah, okay, I'm gonna get this right.
I can do that. Oh, well, 77510.
77510.
Yes, sir.
Okay. All right, how much time do you need to hire a lawyer?
I just started the job, at least a month. They give me 2 paychecks.
I'm gonna give you 6 weeks, okay? Six weeks.
Okay.
Come back. You don't have a lawyer, we'll work on it some more.
Okay.
Tell me what the update is. Until then, Mr. Dusler is your lawyer. So if you need to get any advice, get it from him. He'll give you, a contact information. And just let us know what the status is. Okay, but we'll see you back in 6 weeks. Young lady, okay? Thank you. And if you hire a lawyer, give them that resetting so that they know you have to be here.
Yes, sir.
Noah Niemeyer.
Judge, to my knowledge, he's still in Harris County Jail.
Noah Niemeyer, 25 CR 820. No answer in the courtroom. I asked the bailiff to call into the hall, please, for Noah Niemeyer. Okay. We've got a note here in the file dated actually today that from professional bail bond out of Beaumont. And it states that the defendant is currently incarcerated in the Harris County Jail and has been so since August 5th. That's correct. He's going through an inpatient rehabilitation program before he can be released from Harris County. The last 3 to 6 months. At this time, we do not exact release. We don't have, I guess, what they mean. I am attaching his book for your review. If there's anything we need, we'll let me know. All right. So what we're going to do is reset for a review. Let's reset in 6 weeks just to see what the status is. Okay.
Judge, I did just check. He is still in Harris.
Okay. We are not going to revoke his bond. And Kiana Walker.
She's here. Here. I think she's going to be
23 CR 2055. Kiana Walker.
Walker. Yes. Ms. Walker, over.
right there. She's got to get your fingerprint.
Raise your right hand. Do swear or raise your right hand. Do swear or affirm. Read the name of yourself. You got it?
Always get him on the right hand, please. I raises the left hand.
Yesterday, I think Lacey said she had it. Which, remember?
Okay.
Yeah, she fixed that. She turned around and then everything was fine. Amazing.
What?
23 CR 2055 is now called the state of Texas versus Kiana Walker. That is you.
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, ma'am, this indictment that was handed up by the grand jury, it looks going on almost 2 years now. It states that on or about October 12th, 2023 in Jefferson County, Texas, you committed the state jail felony of theft. It looks like perfume or fragrances like that at the Ulta Beauty Supply in Plugdale Mall. Do you understand what you're charged with here?
Yes, sir.
A state jail felony, if convicted, this means that you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached where you would be sentenced to 180 days in the state jail. Is that your understanding of the agreement? Is that right?
Yes. Because she's got credit for more than that.
Was there any restitution here?
It's been paid.
It's ordered to be paid by a different defendant, Judge.
I just want to make sure that people who were victims get their value back.
Yes, sir.
We're talking about $2,500 worth of merchandise. What is this? Oh, it was a all-out blitz by a group. How is this money being paid back? It's going to get paid back, or I won't take the deal.
It's already been ordered by the co-defendant. And that's correct. I don't know if it's been fully done or not. But the offer was, we didn't know no restitution would be ordered on this lady because it already been ordered.
So from the state, where is it?
It's been, as I said, Judge, it's ordered to be paid by.
I know it's ordered.
Defendant. I do not know the status of its collection.
See, the problem with that is that's a defendant. A lot of defendants are ordered to do things in this courtroom and they don't. And then doesn't get done. And then people who are responsible, who are parties to the event, who say, well, that guy was supposed to do it. Well, everybody's equally responsible. Everybody is equally responsible. Just because somebody takes responsibility to pay, if they don't pay, then the business owners go, hey, what about us? What happened to us? We're supposed to get paid back.
We were presented this agreement by the defense judge. I have not had an opportunity to determine where the restitution collection is at.
Well, I'm not going to go on the word of somebody who's charged with being a thief. I mean, we're going to have to get this satisfied because that's what victims plead for, to fix it. So pay them back. If you don't pay them back, they get victimized twice. Until I'm sure that is done, I'm not taking anything. Okay, I'm ready to set it a couple of weeks. All right, so we'll do. Get a resetting.
On a resetting and be back here. Understand.
You said she's already served.
Yeah, she's already got credit for this. Okay. She done much time.
Well, but still, for people, victims are going to get taken care of. That's just the way it is.
The state had just advised me what I'm here because it already been ordered. So
I know it's ordered, but it hasn't been. They got to come through with the promise. There's defendants a lot of times makes promises where they don't fulfill their. No problem. Victor Martinez, John.
I'm not sure.
25 CR 301.
Ready to be here.
Again.
Well, that's Victor Martinez. And he's charged with a state jail felony of collision involving an injury to another person and intentionally leaving the scene of an accident. Okay. Well, we've been dealing with a lot of these lately. It's a state jail felony. If convicted, you face no less than 180 days up to 2 years in a state jail and a fine up to $10,000. Do you understand? It's serious. It's a very important law. When you're involved in a wreck, even if you're not at fault, you have a duty to stay and help anybody injured. That's the law. If you don't, then you get charged with a felony. We tried one of these a couple of months ago here, and the juries don't put up with it. So, what are we gonna do now?
This is an initial.
It certainly is.
If we can get a whole week's time.
You got it, spare week? All right.
You can probably say, study right here.
And Michael Frost. Oh. 25 CR 1006. Michael Frost, what are we doing here today? This looks like it was set from August until today. It says initial docket. Defendant awaiting safety in another case. Daniel Boyd is the prosecutor. Mr. Boyd.
Yeah, Your Honor.
What can you tell me about this? You're charged here, Mr. Frost, with an indictment landed up in August, charging you with a degree felony of evading arrest or detention with a motor vehicle.
Yes.
And also, it alleges that way back in 1993, out of the 248 District Court of Harris County, you were convicted of the second degree felony of illegal possession of controlled substance. So what this means, if all of this is found true beyond a reasonable doubt, you are facing a second degree felony punishment, which carries with it no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. The point being, it's very serious.
Yes.
Are you getting an attorney to help you or something?
I haven't, because I'm on UGD counsel, I just need to.
You're not able to afford a lawyer, is that right? Well, you need a lawyer.
Yeah.
You need to fill out one of those indigent forms. And if the court approves your financial issues, then we can get somebody appointed to represent you.
Judge, it does look like he was ordered to say even he should not go with this case initiation. So.
Last month, I was diagnosed with third-degree lung cancer.
Yeah, you need legal help though to help you through this, especially if you have physical issues too. I know you're concerned about that. The bailiff is going to give that to you. Thank you. And here, you have a seat right over there in the jury box, and we'll let you fill that out. Yes. Yeah. Where is his other case pending? What court is that?
It's out of this court, and she's on probation. And we ordered St. Pete in that probation case, back on July the 10th, but we let it go as this case is still been taken within the case.
Then we'll have to figure a way to dispose of this quick enough, I guess. What did I send us?
John was represented him in the case where he was placed on probation for felony. That will be two
over 5 in that, Your Honor. He has $5,000 restitution in that case.
Okay. When did we do that?
That was November 13th, 2024.
Give me that file again, please.
No, you want the disposed of file?
No, the new one.
Okay. Hold on, Jim. No, proceed.
No, I got it. Okay. So. Well, he's got more of a problem than it appears. He was convicted last November here and put on regular probation, right?
Yes, Your Honor.
Well, this crime, this new one is committed on June 22nd of this year. So after he had been placed on probation in November, and he committed that crime in November after he had been convicted in Harris County in 93. He's a habitual felon. Mr. Frost, you were convicted in November, right? Here?
That was for a state jail felony, Your Honor, on that.
Oh,
Yeah.
okay. Okay. All right. So you're that close to being a habitual felon, which carries with it a minimum of 25 years in prison, a minimum. If you have 2 or more prior felony convictions above a state jail felony, then the third one is 25 to life. You're looking at 25. The third felony is that. But he says it was a state jail felony. So it doesn't apply to a state jail felony, but the point is that this is your third felony offense that we know about. It's time you quit committing crimes. Okay. I need some files here.
The next docket,
Yeah.
here's a stack.
Don? Deuster? Yes, you got it. I'm gonna go to Zane Viewing. Okay, he's here. 25 CR 198 is called Zane Bury. Is that you? Yes, sir. You still carrying around a drug patch? When did that one get placed off? Do you remember?
About 2 weeks ago, I was going to change it to that. I live here. I don't know if you.
How long have you had the drug patch?
Since the time I marked it out.
When was that?
8 months ago, so.
On the right side. I showed her, she had a reason to look at the airbag barcode. The only airbag that was on the side of the vehicle still. David is all on the right side and actually did not. It just happened to have him here to wait on that. And I don't know if I can get you that. So bring him with
So how often do they collect the drug patch and test?
See, in the beginning, they didn't test it on the.
How long? I'm just asking.
I honestly don't know, so on their plug.
Well, I mean, don't they take the patch off of you?
Yes, sir. Well,
Don't you know when that happens, or you
yes, sir.
sleep?
I thought you were asking me when they tested.
No, I'm just asking.
Every 2 weeks.
Every 2 weeks. Okay. And what have been the results of those?
It's all my levels have been going down.
What are the results of those?
I'm not 100% hazardous.
Nobody's told you about them?
They just tell me the levels have been going down. I never been going up.
Don, do you know anything about the results of the?
I was furnished with a copy of this yesterday, which shows me that he's still testing positive, but the results have been going down. The most recent one did not show to the level that it was previously.
Yes. It doesn't matter.
I haven't been using any.
I don't care what you have. You've got 6 positive tests here. The last one was a drug patch that was collected a week ago.
But I haven't been in 2 weeks.
I don't care what You are. While you're not, on my watch, you don't test positive for drugs. You got six positive tests here for cocaine.
I can take a drug test right now.
Good for you. You failed the other tests.
You know how cocaine came up. I do not.
It must have been a mystical event, a miracle.
So
But this is science. You know how many? I wish I had $1 for everybody who says, "I know I'm testing positive. I don't know how that got in my system."
But I put my right hands on the Bible and I swear.
You right hand. I've heard that one before. I swear to God. I know. I know.
Everything.
Every polygraph goes off in the city when you say that. No. Yeah. No. Yeah. Just because levels go down, that's not. They're supposed to be zero. Nothing. Not a hint.
Sir,
You've been testing positive on cocaine now since. Let's see.
That's what I'm saying.
Since June, buddy.
I don't understand how I can test for cocaine.
But I'm going to rely on science, not your word.
I understand.
Okay. All right.
I understand.
All right. What is this bond?
$30,000.
Yeah. Your bond is revoked. You're going to go to jail. Sorry. The rules are the rules. First thing, don't commit a crime. Illegal possession of cocaine is a crime. It's in your system.
Don't possess it. Never touch it.
It's in your system. You're possessing it. You don't have to have it in your hand, sir. It's in your system. Don't interrupt the court when I'm trying to stop. You're going to debate me?
No.
Really? You're testing positive on these tests 6 times in a row here. Every 2 weeks, 6 times. You're testing positive and you're going to debate? It's not a debate.
No debate. I just want to tell you.
Shame on you.
Possible circumstances. I work in a recording studio. I don't know what people do. If I ask them to touch it or any of that, it's not me using it. I will not use that drug. Okay. The most I've ever done is smoke marijuana. So, and I don't even do that anymore.
Sorry. You got cocaine in your system. How it gets in your system, I don't have to figure it out. I don't have to prove that. The tests that they're coming back are enough. You shouldn't be testing positive. Change jobs if that's what it is. Do something else, but you've tested positive 6 times. No one does that. That's a rare event here. My God, I get 2,500 cases a year for 18 years. This is a rare event. And you can't attribute it to a miraculous event. It's not a miraculous event. It's science. Your bond is revoked. You're in custody. So hold on before you leave. Don, what are you doing next?
He that's actually was going to be looking on somebody. So you come back after this, you'll see they state something.
But your bond is revoked. I can't trust you out there. I can't trust you out there, and your excuses don't work. So what I'll do is review it in 2 weeks to see if he's been able to get somebody from jail to retain. You're his lawyer, though. Advise him, Don, on what his options are. All right, that is all. I should do this. This but it only said if denial was the only thing is the only thing that you need to do to keep out of trouble. I guess everybody would be denying it, but the point is that we're doing the tests, and either we're going to rely on the tests or we're not relying. We've only relied on them for 15 years.
They just take them both record.
Anyway,
And I feel sorry for kids. Y'all should do this.
Ms. Lucas is here. She's got 2 cases and she is working on trying to hire an associate and asking the court to give her a little time.
Is that what you want to do? He's a fine lawyer, but you can go hire some people. You are charged with two motions to revoke. No, there's just one, a new case. I guess it's the burglary of a habitation, which is alleged as paragraph 1 here. All right, this is the 18-30538 that you were on probation for is assault, a 3rd-degree felony assault on a public servant. Burglary of a habitation is the new case, which is a 2nd-degree felony. If convicted, face up to 20 years in prison. The motion to revoke probation on the earlier case alleges you committed burglary of a habitation as a violation of probation. Failed to provide verification of performing community service hours and failing to pay court-assessed fees by being in arrears over $6,000 as of June 27th. He's your attorney right now. You can go hire somebody, but I want this motion to revoke probation hearing in 2 weeks.
Everybody all right?
You either be ready or not, but in 2 weeks, you can hire somebody or but it's not in front of a jury. It's in front of me only. We're going to resolve this. We're not going to lollygags. And I'm setting it in 2 weeks. Hearing on that burglary, on that motion to revoke probation. And on this one, as you probably know, if convicted, you're looking up to 10 years in prison. Okay. That's what we're going to do. And if you hire a lawyer, they have to be ready in 2 weeks because I'm not waiting. We're moving forward. Get a resetting. And thank you. Okay. Wayne Francis. Wayne Francis.
I gave something to go with Judge. He's in this process of hiring Mr. Paget.
I saw Mr. Paget out there.
They're on. Good morning.
Wayne Francis, we have 3 cases, 4 cases. Oh boy. Okay. Here we go. You are Dwayne Joseph Francis, right? Okay. You're charged in 4 indictments. In 24 CR 1437, the 3rd-degree felony of evading arrest or detention with a motor vehicle carrying with it up to 10 years in prison. In 24 CR 1438, you're charged with the state jail felony of theft, which carries with it up to 2 years in the state jail. 25 CR 69, a state jail felony of theft, which carries with it up to 2 years in the state jail. And 25 CR 70, the more recent case, that's a theft and carries with it up to 2 years in the state jail. Is there something about thefts that you're hooked on right now? Let's see. It says here in 1438, a mulching head was stolen, which is a value of $2,500 or more from Drainage District 6. And then was sold. A Dodge automobile was stolen, according to indictment 25 CR 69. And here's another Dodge automobile. Stolen.
Only to help people.
All right, so all of this looks like it's up to 16 years in prison for all of these. That's the potential you're looking at. What do we do today?
Your Honor, he's giving out this weekend. I have a relationship with him. I can tell you this. He works a full-time job. He's very productive. I can't speak on
his honesty.
Well, I can only tell you what I know.
I know what the grand jury thinks.
I understand that, Your Honor, but I'm just telling you that he is a taxpayer. He does get up and work a full-time job every day. And I can tell you a little bit more about these once he hires me and I dive into it, and I assure you that I will. If you will just give us a standard reset, I assure you I will not drag my feet. We'll get this recovery and we'll move forward on this case quickly.
Okay, what's the total amount of restitution? Do you know from Stan?
I believe the majority of the items were judge.
That's my understanding, but again, I don't.
The only one I showed is $195. All the rest of them, all the restitutions are recorded. That's what I've shown in my notes. So
That's what my client told me, but again, Your Honor, it will just give me a little bit of time to dive into this, just a standard reset.
There's nothing standard in this room anymore. I'll give you 5 weeks.
That 5 weeks will be plenty. If he does what he says he's going to do, he'll hire me this week, and then I'll have the motion filed on Monday.
Okay. Anything else? That's all. Thank you. Get a reset. Thanks, Mr. Patton. See you.
Well, you're going to see me quite a bit. It looks like it. That's just the last case.
Sam Hodges.
We'll just make up on each other quite a bit.
Sam Hodges had 4 cases at this point, huh?
Yes.
What are we doing?
He had an attorney in Houston was representing him. Who withdrew.
I think I need Sam Hodges files.
I believe you allowed his prior attorney to withdraw. And he tells me that he is working on hiring someone here locally to handle it. That's really not.
We're not waiting. Look, this 22-40933 was indicted 3 years ago. I'm not waiting.
Judge, the bill number 23 DCCR 2252 is a robbery. That case has been on the trial docket. The state's been ready for that. I ask if there's any reset that it goes back to the trial for that case.
Are you represent? I've never met him until today. There, but he was represented by his attorney Houston. He tells me when I met him this morning, he tells me that we're going to get somebody.
You can do it. We're going to try it. Mr. Deuster's here. We're going to pick it up and try it again.
There is
and we can. You got to get a lawyer involved, or he will handle it one way or the other. But we're not going to. This is way too old. These are way too old.
Also, there's an underlying concern as to whether or not his bond conditions are appropriate, because we picked up 2 additional charges this year while that robbery case was pending under bond.
Yeah. Okay. So 22-40933 is the oldest one. And that's a state jail felony of engaging in organized criminal activity. And the indictment shows 5 prior felony convictions dating back to 2007. Looks like that state jail felony is going to be punished as a 2nd-degree felony.
That's correct.
So he's looking at 2 to 20 on that. Then we've got a robbery. 2nd-degree felony robbery with a prior felony possession alleged in paragraph 2. So that's a 1st-degree felony punishment.
That's correct.
In 23 CR 2252. Yeah. And that was an indictment handed up on December 23. Then we have 2 newer indictments here handed up by the grand jury on August 13th of this year. Burglary of a vehicle committed allegedly about April 10th of 2025. Also April 10th of 2025, a 2nd indictment, burglary of a vehicle, both state jail felonies.
So, Judge, even though they're styled burglary vehicle, these are the nature of a jugging offense where the defendant along with someone else spotted someone getting money at the bank, followed them, and then gets their money when they step out of the car. So they take the person out of the mix to avoid the robbery that we're dealing with. And the other calls, they wait till the person leaves the car, then they go and get the money out of the car. They did that in Beaumont and Needham, and that's these two charges on that same day.
What are you asking for?
I need this bond addressed because apparently I know one of the conditions is that we're not committing any new offenses, and apparently the bond of whatever amount it is isn't sufficient enough to give Jefferson County any kind
What
of
is the bond?
That I don't know, Jeff.
240933, the bond is for $24,000 on the 23 DCCR 2252, the bond is $40,000.
Who ordered that?
Yeah.
As I'm looking at, among other things, the public safety report in these files, which clearly show
Just the $40,000 bond.
two full pages of arrests and convictions, 15 on each page. So those are considered, certainly by this court, by law, any magistrate's supposed to be reviewing those.
Yes, sir.
When they're setting law, or you get in trouble. Yeah.
The $40,000 bond, it looks like we set that after a positive drug test.
What day?
That was October of 2024. $40,000 was a drug action. And then the older pay.
No, hold on. I'm talking about the two new cases. There's no way I did that. These two new cases weren't indicted until August of 25.
No, Judge, the $50,000 is on the robbery case.
Oh, you're talking about the initial thing.
Yes, sir.
All right.
So we set the bond
Okay.
of $40,000 and $24,000 in the robbery and the engaging in organized criminal activity.
Yeah, I'm talking about the new burglaries. That's all I'm.
The new burglary cases, he has bonds of $15,000 and 1022 and $6,500 and 1023.
Who said that?
Okay, let me look. Yeah.
Because there are public safety reports in these files that show the criminal history, which she's going. Anyway, just. All right. You know what's about that? No, not on this watch, this court's watch. You're going to be charged with felonies, including violent crime, robbery, and then thereafter, while you are on bond on those two, shortly after you're placed on bond, you're going to go out and commit more crimes. All of these bonds on each of these 4 cases are raised to $100,000 each.
Thank you, Judge.
You will be at home confinement. I can't trust you leaving your house. You're going to be home confinement. Plus, you have to have a GPS device so I know where you are at all times when you're not committing crimes. And when you're committing crimes, 4 of these. It wasn't enough. It wasn't enough. And we made a big deal on these first two cases, warning you of the seriousness of all of this. So you quite naturally go out and commit more felonies. That's the way the law works. When you commit more felonies, everything goes up in price. It's as though you're completely ignoring the rules. And if this is true, where you're doing what's called juggling out there, those are serious infractions. And that's organized crime. And that has even higher punishment ramifications. So if you go out and you can hire a lawyer, but until then, he's your attorney. What are you announcing right now, Don? It was an announcement. Okay, we said this 4 weeks. Thank you. Everybody start getting ready for trials.
Yes, sir.
Sharon Lee, please. You're in custody.
You should have a notice of representation from Wayne Walker.
How many cases do I have? Two cases? You're Miss Lee? Is Mr. Walker here? Have you hired him?
Yes, sir.
You've already done that?
Yes, sir.
Did he know about being here today?
He said he
was going to be here?
He said he texted Ellie
Uh-huh.
or emailed Ellie.
She confirmed with me that she has the representation letter.
See, the thing is, it says the last event in the file is in the process of hiring Mr. Walker. I wonder if all the papers have been.
She finally came in this morning.
Oh, maybe it just didn't process through. But Ms. Lee, I can't tell you enough about how serious these two cases are.
Yes.
These are both first-degree felonies, which are rare for money laundering and thefts of property. Rare first-degree felonies, which means the values of what was taken is enormous, according to what the grand jury alleges.
Over $300,000 worth of restitution is owed, Judge.
In each case is what it's being alleged, but you're facing no less than 5 nor more than 99 years confinement or life imprisonment, and a fine up to $10,000 can also be assessed for each of the two cases.
Yes.
So that's 2 life sentences, $200,000. Okay, that's what you're looking at. I'm going to set this for an announcement in 4 weeks. And I guess we'll send it to Mr. Walker. He's apparently the person who is going to be representing the defendant. Get a resetting, man. Thank you. Justin Moore.
Your clerk got a notice this morning of verification. He's in hospital.
What do I know about Justin Moore being in the hospital on the day he has to be in court?
The bondsman did send us a letter from the hospital.
Okay.
Yes. Ironically, this happened the last time he had setting on August 7th.
Okay. I always wonder about typewritten notes, official notes that are unsigned. That always triggers a question in my mind.
Yes, sir. This is
So anybody can do this.
This is another individual that kicked up a felony offense while out on bond, Judge.
What's, which is the new case, the 1784?
The newest case, Judge, is 25 DCCR 0968. It was indicted on August 6th, the day before he was supposed to appear in court, and he was in the hospital.
I don't have that.
Oh, sorry, Judge. It didn't.
Cat and mouse. It's a little game that's played all the time. Cat and mouse. Looking for the other note from his teacher. As it were, I don't see it in the file. Mention it, but I'm.
You what? Look at our email, did we have the previous one? Apple.
He said, no.
Yeah.
We didn't talk on it. He said, can I put it? It is the one thing.
All right, Don,
Thank you.
you know what his bond is on the 25 CR 96?
I have no idea.
Mischief.
I've never met him. We've had three other court appearances that he failed to appear and warrants were issued, but apparently something came up after that when you withdrew the warrants. So I have no idea what the bonds are. I assume they were still the original bonds, but I can't answer that. I forget. He's not appeared on any of his prior court appearances.
Okay. We've got 3 indictments in 2023 handed up. Now we've got a 4th one that was just handed up last month on this new charge of criminal mischief and an aggravated robbery prior conviction. And it states on or about April 15th that all occurred of this year, which is after he posted the bonds.
Supplemental side.
That's the one.
Okay, so you got that. And that doesn't have to be. Okay.
What are his, what's his bond on this 25 CR 968, please?
1 second.
Showing him to be a transient, even though had addresses Beaumont in the 3 previous. Now he's a transient, according to this new. He's on his way out. Moving target.
He has an active warrant for that shit. He doesn't have a bond set, it's an active warrant. On 25 DCCR 0968. He has not made a bond, he has a warrant out for that case.
Okay.
Just call him at large until he's arrested. Then the jail 7 days, I guess.
And what the court is going to do, though, because you can imagine how I don't trust this set of facts at all. And
Folks, once again, I'll show up over the hall. And the signing, we start collecting.
the court is reviewing the defendant's public safety report that is in this case file here pending. And it reflects a criminal history dating back to 1995 with convictions of unlawful carrying a weapon, illegal possession of a controlled substance, among other convictions. And the new indictment alleges that Mr. Moore has a previous conviction in 1997 out of this court for the first-degree felony of aggravated robbery. So there is no bond in this case ordered. A warrant is issued when he is released. He must be taken into custody, and then we will get have him brought forth for a hearing as soon as possible, so that we can figure out of these 4 charges, the 4 cases pending, what is in the best interest of justice. So a warrant is issued for his arrest. No bond is ordered by this court until this court has a hearing. Mr. Moore. All right, Don, how about, well, that's it, I think. That's it. Come on up.
Who is it?
Voting Hills.
Do I have that file?
Covering Hills.
25 CR 84. Cody Nails. That's you? And you're here with your attorney, Mr. Paget, and the state's attorney. Does the defendant waive a formal reading of this indictment and this arraignment? Can we proceed in summary?
He does, and yes, Your Honor.
Are we just on paragraphs 1 and 2?
That's my understanding, just on paragraphs 1 and 2.
Says he's got a prior 2002 robbery conviction out of Travis County, which would enhance this
Yes.
to a second degree
That's
felony. And
I
are
believe
we
you
doing
would
that?
pled it
We
to
are
the
doing
second
that.
degree. So we are,
You're going forward as a second.
yes, I thought that's what we had.
That is our understanding.
Yes.
That is.
I believe the paperwork was done as of the second.
Why? If it will not exceed a cap of 8 years in prison, why are we doing that? It's in the event he was given deferred or unadjudicated probation, is that it?
Yes, Judge.
That's why? Okay. All right, then 25 CR 84 is now called your Cody Deshawn Nails. This is the president, your attorney, and Mr. Paget and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, sir, paragraph 1 and 2 of this indictment allege the felony of operating a motor vehicle in a public place while intoxicated. Paragraph 1 states this occurred on or about September 5th, 2024 in Jefferson County, Texas. And paragraph 2 goes on to allege you have 2 convictions of DWIs, operating motor vehicles while intoxicated. 1 conviction, 1998, County Court of Law 6 of Travis County, Texas, and the other July 29th, 2008, 331st District Court of Travis County, Texas. Which means there is another DWI somewhere out there that we don't know about, but
that's correct.
But it's not a deal breaker. Paragraphs 1 and 2 constitute a 3rd degree felony. Do you understand? However, there's a 3rd paragraph which alleges that you were finally convicted of the 2nd degree felony of robbery on or about September 6th, 2002 out of the 331st District Court of Travis County, Texas. So if that were all found true, paragraphs 1, 2, and 3, you were looking at 2nd degree felony punishment, which means you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? An agreement, again, has been reached where you would be pleading guilty, and whatever punishment will not exceed a cap of 8 years in prison. So you're looking at no less than 2, no more than 8 years confinement in prison. And also, I guess, deferred or unadjudicated probation is a possibility.
Yes, Your Honor.
So everybody feels like that's regular probation is not.
Yes, Your Honor.
He's not eligible for regular probation. If I follow this agreement, you have no right of appeal of your case. Do you understand, sir? How do you plead to paragraphs 1 and 2 constituting the 3rd degree felony of operating a motor vehicle in a public place while intoxicated? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes. And paragraph 2, which alleges those prior DWI convictions in 1998 and 2008, are those true and correct as they are alleged? And are you pleading true and correct to those voluntarily and because those allegations are true? And then finally, paragraph 3, which alleges that you have a prior robbery conviction on or about September 6, 2002 out of Travis County, Texas. Is that allegation true? It's true. Are you pleading true to that voluntarily and because it is true as it is alleged. You understand, by pleading guilty and true to paragraphs 1 and 2 and 3, again, you were looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. You understand? And this means your punishment could be based upon the agreement. Again, confinement in prison, no less than 2, no more than 8 years confinement. Also, deferred or unadjudicated probation could be assessed as well. That's an option for the court. Do you understand all of that?
Yes, sir.
All right. What I'm going to do is ask for a pre-sentence report. And we will come back and everybody gets to add anything you want to the information provided, make your argument, and I'll make my decision. Okay, sure. Please get a resetting. Thank you.
We'll have a lady on the docket.
Another lady on the docket.
We'll have a person on the docket.
Oh, a person on the docket.
Right now, that's.
I didn't. Let me see where this is. I've got Reagan McCain.
Well, yeah, I think we probably need to approach. She indicated she was
I got a Norman Marshall that was reset.
reset.
Okay.
And
I got a Reagan McCain.
McCain was on.
And then a Cody Net. Well, we are.
Knows me play.
Yeah, just that.
So McCain, and she was she had a warrant for quite a while, and she got arrested. She indicated to the court last time she was hiring an attorney.
Who is it?
Reagan McCain. So we might want to call her up because I haven't had communication with her in well over a year.
Okay, 2 cases are now called involving Reagan McCain in cause numbers 23 CR 1517 and 23 CR 1520.
Ellie has.
Is that her?
I don't know.
Yeah.
Are you Reagan McCain? Every so often you ought to talk to your lawyer. He's your lifeline. He says you haven't been contacting him. Why would that be?
Well, she's indicated last time that she was going to hire an attorney. I wasn't in here last time because she showed up on the docket surprisingly.
The last time was August 14th.
That's correct.
Let's start with someone else. Who did you hire? Thanks for that waste of our time. So he's your lawyer. What are we going to do next?
I'm going to be filing a motion to withdraw. Again, I was thinking I would be receiving something.
Okay.
Substitution.
You're going to be, when he withdraws, you're without a lawyer. You can represent yourself. Is that what you want to do?
No.
Well, you better get a lawyer. You better move quickly because he's about to file something and we're going to let him go and you're by yourself.
Well, I've waited quite a lot. I
know. Well, that's, whose fault is that? You know, there's one case, it's a 3rd degree felony up to 10 years in prison. And the other case, state jail up to 2 years. So that's 12 years in prison. That would be important to me. I'd be communicating constantly with my attorney, not treating it as though it's something that is in the back of the importance line. Don't you think 12 years in prison is important? Yes. Yeah, I do too. Well, I thought maybe you were thinking differently, but you better change your ways because we're move forward on this. What are you asking for today, James?
What are you asking the court for today? Ms. McCain? To speak up here.
Are you asking to be released immediately?
I am, but I haven't filed a motion because quite frankly, I was just notified she must have gotten arrested. She had a warrant for quite a while, close to a year.
For what? For what? What did you get arrested for? This stuff?
Yes, sir. My understanding is she missed a court date. It's been quite a while, a little over a year ago. Year and a half.
What's your bond? Do you know?
No,
No, because somebody else posted your bond, right?
I posted mine.
How much was it?
I had put down like.
Everybody knows when they post it because it costs money.
What are you going to do? Last time you were going to go.
No, when I came here, you was so good. So.
I wasn't going to happen. I wasn't until I had to do
Yeah. Cause you know, never really, so I just.
What are they?
Her bonds are 25,000 and 7,500.
Yeah, that's $32,500 in bonds. And you're not paying him.
Well, I haven't even spoken to him in a year and a half.
It's been a while.
I don't even recognize him.
You know, everybody gets their bonds first, but
I mean, I'll tell you this, Your Honor, I have no problem representing her. I just they have not been able to communicate with an organ. I'll tell you what, you could give us a regular reset and you either need to hire me or you need to hire another.
4 weeks. You got 4 weeks to figure. Y'all got 4 weeks on these two cases, okay? Let's get a resetting.
I'll give you
Get a resetting right here, and then y'all can talk about it.
And I just have a part of this.
Lisette,
I've just had no way to reach her. Done everything I could.
I don't understand.
Been in the same office for 28 years.
I would be banging on your door at 3 a.m, but that's just me. I've never seen, it's an experience, a social experience doing this job. Okay, I need Lisette McCartney at 5.
Don't run off. No, not right there. I'm trying to get a hold of a lock-in.
Chickens are
Your turn.
moving in different directions.
I have a way of keeping up with people.
25 CR 80 is now called Lisette McCartney. You were charged with on or about April 6th of 2024, committing the offense of operating a motor vehicle with a child passenger while intoxicated. So you were looking at no less than 180 days up to 2 years in the state jail. Serious, fine up to $10,000 and be assessed. And this was an automobile accident that occurred.
That's correct. A minor accident. This guy's, you were approaching on Mr. McCartney, and I didn't want to. I didn't want to say anything without you at the bench.
All right, Judge.
No, it's she had 3 people in the area. I don't think she heard the call.
What was the result of the blood specimen?
I believe it was a 244.
That's
244.
That's 3 times the legal limit.
Your Honor, we have I was dealing with another prosecutor on the case. This is my first appearance with this case.
It's been around since January. You know.
I understand that, and I'm not going to get into the issues.
What do you want to do today?
Okay, just had a witness give a statement to an investigator. I just need a regular reset on this. You can give me 4 weeks.
Got it.
And let her evaluate it and see what she wants to do with it.
Okay.
So we'll make a decision and then come back.
Okay.
Thank you.
Good reset. Thanks, Jen.
Thank you. Thank you, Your Honor.
Scott. There you go, Judge. We got you on Randy Arline.
Simply just.
Okay, Randy Arline, please. We'll sign need that file somewhere. In front of that lady, she's going to swear you. Thank you.
Okay. So.
Okay, on Michael Frost. Where's Michael Frost? He's filed a indigent form. Where are you? Michael Frost? There you go. Oh, he's asleep.
No, over here, I need a fingerprint, you start.
We'll wake him up later.
If you're right, I'm right.
Criminal district court where everybody's going to go into prison.
No.
That's how. No, let him sleep. Sorry. Yeah, that happens, but rare. Apparently, people are alert in this world because so much at stake. But a lot of folks, they just find it better to go to sleep. Mr. Online. There we go. Randy Craig Arline, right? 25 CR 107 is called. Mr. Arline is present with his attorney, Mr. Rennick, and the state's attorney does. The defendant waive a formal reading, hello, of the indictment and the arraignment. Can we proceed in summary?
Yes, Your Honor. And just going on the
Prior convictions.
going on the first paragraph, Your Honor.
It's kind of getting a bargain deal here there, buddy. We go back to 2011. No, 2007. 1994. 1992. 33 years. The felonies. Including one, two. Three prior burglary convictions of habitations. And so we have another burglary of a habitation. See how this ends. Mm-hmm. 25 CR 107 is now called. And Mr. Arline is present again with his attorney, Mr. Rennick. In summary, paragraph 1. Okay. This is very confusing, the worded indictment. I've done this for 40 years, and this one is an odd one. Okay. It alleges in the indictment that on or about January 17th, 2025, in Jefferson County, Texas, you committed the second degree felony of burglary of a habitation. Paragraph 1 states you committed the burglary without the effective consent of Rebecca Gaspard, the owner, with intent to commit theft and assault. And paragraph 2 states you committed burglary of a habitation without the effective consent of Aaron Gaspard, the owner, with intent to commit theft and assault. Why is that worded that way? I mean, paragraphs 1 and 2 aren't two separate offenses, are they? They're
No, Your
one
Honor.
offense.
Right, yeah, it should have been out of the same one.
But I guess the husband and wife who own the home.
Yes, sir.
And then when you burglarize, you have each owner is a victim.
Yes, sir.
But are we going on paragraphs 1 and 2?
Yes, Your Honor. We'll go.
Both of them? Okay. So, and it's kind of.
Yes, sir.
Paragraph 1, though, it says paragraph 1, but it's the second paragraph, not the first paragraph.
Yes, sir.
So paragraph 1 is on the is referring to the actual second paragraph, and then paragraph 2 is actually the third paragraph. It can't get more confusing here, but with you understand what you're charged with that confusion. So it's a second degree felony if convicted. Again, you're facing no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand, sir? An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding? of the agreement as well. Another case, 25 CCR 440 would be dismissed as consideration in this agreement. If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this case, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
I can show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1.
No objection.
Tendered into evidence without objection. Is admitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. The indictments read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is way.
Yes, Sean.
I'm going to follow this agreement then, sir, and make the following findings: that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second-degree felony of burglary of a habitation. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened today, sir?
Yes.
All right. You're going to be taken into custody, as you understand. Anything else?
No, Your Honor.
All right. That is all on this case.
Thank you, John.
Yes, sir. I don't see a dismissal in the queue.
It's a misdemeanor, Your Honor. It's
okay.
Judge.
Oh, then it's not fine. Then to deal with it. Okay.
Yes.
Brent? Okay, I've got Janila Delahuse. Delahuse.
That's the last step. Files judge.
Thanks.
Do I?
Posting.
That's you? Okay, then 25 CR. What's that say?
So we say not in the meeting.
Let me see. Thou shalt not try me.
Oh,
Yeah.
they need at the bottom.
Yeah. Yeah, it's not appropriate. It's not church, but it's still a place of honor. Don't wear things that have messages on them unless it's something about the Constitution of the United States. It's not a comment. All right. In 25 CR 726, in this case, you were charged with the second-degree felony of burglary of a habitation. What are we doing?
So, did we get one more reset on this telephone system so we can look at the discovery and talk with English?
Is 3 weeks good?
Yes.
Hold on. Okay. Yeah, that's good. Get a resetting. And Levon Golo.
I believe she would like to review the videos on that one. I just got an offer from them. And she won't she's considering she's going to make sure it's, so I'm sure
this one's.
Yes, yes, sir. Just got it. Made me go just now.
I know. I can see where this goes.
Quick reset. Just that way she can come in and look at stuff.
You were charged with the second-degree felony of aggravated assault, ma'am, in 24 CR 1314, which means you are facing no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. This one's been around a long time, and I understand. This one was transferred to this one. I understand. This isn't your call. How much is 3 weeks going to be
Yes,
good? You
plenty
think?
of time.
Okay, thank you. Please get a reset then. Thank you.
This next one, I need to get a discovery from.
Braden Hensley.
Yes, sir. I was unable to get with Ms. Staub last week because I.
Braden Hensley, come forward.
Yeah, I need to discover.
How I did that.
Visit on this.
24 CL 515 is called you, Braden Hensley.
Yes.
And you were charged here with a third-degree felony of illegal possession of child pornography. Serious, carries with it up to 10 years in prison. So, and Mr. Turk is your attorney. 3 weeks going to be good on this. This one is another. This one's even older than the previous one.
Let's go get together. I need to go visit with Mr. Ham now that I know who has it.
Okay, get a reset. Thank you. I'm here from that last. I have Patricia Johnson.
There should be a please.
I don't know how I did it. I need to think about that defender. Johnson, over here, please. So, Ms. Johnson, please raise your right hand. You swear or not to tell the truth, so be God. Keep up your right hand, correct?
Right.
Place it flat.
Thumb grip. And nothing but your right thumb flip. So help you God.
So right there. So there you go. This one time judge.
25 CR 492 is called Patricia Johnson. That you, ma'am? Speak out so this lady can hear you. Thank you. And you're here with Mr. Turk, your attorney, correct?
Yeah.
Good. All right. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
You may, Judge.
In summary, ma'am, this indictment alleges that on or about March 30th, 2025 in Jefferson County, Texas, you committed the state jail felony of charging you with knowingly, recklessly, or with criminal negligence, placing a child younger than 15 in imminent danger of death, bodily injury, or physical or mental impairment by operating a motor vehicle irresponsibly, it looks like. And you did not parent. And apparently operating your motor vehicle with the child passenger irresponsibly, crashing into a residence, and while the vehicle was occupied by the child, and you did not voluntarily deliver the child to a designated emergency infant care provider as required under Texas Family Code Section 2262.302, which is a state jail felony. You know, I must say, I'm really not familiar with this statute, but so if the child passenger is involved in an accident, a collision, then the duty under the law is to bring the child to the hospital or a medical care facility, whether or not the child is injured.
That's not the connection, Judge.
Is it indicted okay? Because I think there's something missing here.
No, so
in the wording.
All right, so the facts of this scenario.
No, I'm just looking at the indictment allegations.
Right.
Just the indictment allegations is yeah, I know we have some interesting things.
Yes, sir.
Because we deal with them in.
So if I may, Judge, the language there at the end about a defendant not voluntarily delivering a child to a safe place is statutorily required. In this scenario, it's not necessarily that there was a wreck.
Okay.
It's the fact that she was traveling at 90 miles per hour and placed this child in fear. Yes, there was a wreck. There was a crash. And this language at the end of the indictment is statutorily required because if you're going to do something that could place a child in danger, you have a duty to put them in a safe place. As I understand.
Oh, okay. Okay, so it's not a crime to intentionally, knowingly, recklessly, or with criminal negligence engage in conduct placing a child in imminent danger of death, bodily injury, or physical impairment. That's not a crime?
That is a crime, Judge.
But it goes on to allege other elements.
Yes, sir.
Okay. All right. This is a state jail felony, and that carries with it, if convicted, ma'am, no less than 180 days up to 10 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here? An agreement's been reached between the parties where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 5 years in length, fined $500. There would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? Yes. You do well on probation, it will be dismissed and you can move on with your life without a conviction. That's what's good about it for unadjudicated probation. How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are indeed guilty of what it alleges?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
If nothing further, I'm going to follow this plan and this agreement, and I will find, ma'am, that you are indeed mentally competent to enter your guilty plea, which is legally and voluntarily made. You understand fully what you're charged with. You have pleaded guilty voluntarily, knowingly, intelligently. There is enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony. But I'm not going to find you guilty so long as you follow these terms and conditions of probation. But you will be placed on a deferred or unadjudicated program for 5 years. You do well, it will be shortened to 1/3. There will be terms and conditions of probation, which are normal and customary for this type of offense. Oddly enough, most of these terms and conditions of probation are what I and everyone in this room are required to follow. So it's not like you're having to go swim the Pacific or do something extraordinarily difficult. These are things that are relevant to helping you make the right decisions in the future. All right. Do you understand what's happened today? Please see the probation officer. Thank you.
Judge, Miss Lane is here. That's the next one. I think she made it down to column 3. With yeah, it's very another matter. If you want, I can go collect her. Or we can take care of Mr. Milton.
Where is she? At a misdemeanor court?
Yeah, she's walking in, but that's Jack came and collected her a few minutes ago to go take care of what it was done there. And you grab stuff like that what you want.
Who is it?
Miss Lane. She is here and she is a.
I hear the door opening and closing, but no one's coming in. It's again another mystical event here in criminal district court. Mystical. It's defies the realist.
She's here.
Let me get straight. The chaos lane.
She is here.
Where is she?
County first.
Because she's not here. You said she was here. She's here in County Court Law 3.
It's Spirit Judge. She's here.
How about Alan Lofton?
He's here, Judge.
Or is he in county
He
court
is
of law
here.
four?
By your definition, he is.
All right.
I need her to.
Come on up, sir. Yes, another game of Where's Waldo being played here in criminal district. Well, where's Waldo? It's always
Fill out.
Where-
Raise your right hand, you swear or tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, you got your word of temperament. Place it flat on the box right there. Take it up one more time. Place it flat right here. Okay, do the hand from the judge.
God bless you out there. Here's Alan Michael Flaw. Everybody. Twenty-four CR 1675 is now called Alan Michael Lofton, present with his attorney, Mr. Turkin, the state's attorney. What are we doing? Okay, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
You may, Judge.
In summary, sir, this indictment alleges that on or about July 7th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? Yes. This is a third-degree felony, which means if convicted, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Yes. An agreement's been reached in your case where you would be pleading guilty and then placed on deferred or unadjudicated probation, which actually can be up to 10 years in length, fine $500. The court determines how much the length is. If I place you on deferred or unadjudicated probation, will you do well? Yes. Then you're going to be, it will be dismissed in 1/3 of whatever the time is. If I follow this, you have no right of appeal. Do you understand? Yeah. How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will. And because you are guilty, I'm going to show you where it's marked here, State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents all true and correct? Yeah. State's Exhibit 1, without objection. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with? You're pleading guilty voluntarily, knowingly, intelligently. And you are guilty of this crime and any lesser included offenses. It's totally satisfied with the representation provided by your lawyer. I'll do so if he does. Yeah. You okay with that?
Yeah.
Yeah, State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived here. I will follow this agreement, sir. I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, but I'm not going to do that. I'm going to place you on deferred or unadjudicated probation so you don't have a record. I'll do that. How long are y'all asking for?
5 years.
5 years. There will be terms and conditions of probation. You will be, you must pay a fine of $500, and we're going to make you do defensive driving course. That's good, though. Your cost of insurance will go down substantially. It's a win-win for you, and it'll help remind you of the importance of following the rules of the road here. Thank you. Okay. Okay, thank you. Please see that nice lady. Carson Moore. Carson Moore.
Yes, sir.
I'm just saying your name, Carson Moore. Carson, I don't think I know anyone's that first name.
Spelled like that?
Carson, yeah. So, I don't know Carson, Carson, I guess, but that's generally a surname. Okay, you are Carson May Moore in 25 CR 497. You were charged with the second-degree felony of assault on a peace officer. And your attorney here is Mr. Turk. What are we doing today?
Judge, I need to visit with Mr. Boyd on this one. I think there might be a way to resolve this one and complete. He hasn't had a chance to really get into the video, and I want some highlights to him that may help the case. So just a real quick reset.
Okay. Is 3 weeks good?
Yes, sir.
Done. Please get a reset.
Yes, sir.
Thank you.
Let me go check on this.
Found the highlighted next one, please.
Hey, Judge. Judge, have an attorney's needs to real quick.
Yeah.
They've got something else to.
Sorry,
Yes.
that's,
Yes, sir.
we're not going to do that. We're going to have him back 3 days. Come on up.
Thank you.
You can see you're juggling a lot of balls, and
That's okay.
So who's your different?
It's Justin Woods.
Yeah, you're Mr. Chief.
Yes.
With me,
yeah,
Bill.
Judge. Yeah.
Where is he?
He's, there he is, right there.
Oh,
We're, real quick, the state has made an offer.
Is that true? What a generous thing to do.
He also has a misdemeanor, and we're trying to get that finalized. The DA is upstairs over there. So what I'd like to do, if possible, is reset this for a month or 3 weeks, or whenever the next available period is, to wrap up a universal plea in here and in there.
Is 3 weeks going to be good?
3 weeks would probably.
You got it.
That'd be full.
Okay, get a resetting. Thank you.
Thank you, Judge.
Yes, sir. You can make the honor. Thank you.
What?
You know what?
I don't know how I did. I just went to a warrant.
I can't believe that. How many cases do you have? I've got a Sheena Miller and an Erica Ozan.
No, should have been a race car, but now you today at 7 later. Recording this.
Yeah, come on up. Sheena Miller?
Yeah.
24 CR 2453, you're charged right now with a state jail felony of theft of, it looks like, metal of some sort, copper. And is carrying with it up to 2 years in the state jail. What do we do today?
We're gonna ask for this to be reset so we can re-indict it as a third degree.
Oh. Okay.
The cost of restitution makes it third degree and not a state jail.
So it's gonna be a theft.
Okay, when is all that going to happen? Soon?
Soon, yes, I'm gonna,
Why don't we review this in 3 weeks? Get a
Have to post it.
I don't know. Okay. What's the bond right now?
I already paid it off.
Yeah, but you don't want to pay more. What's her bond right now? Let me ask you, Miss Miller.
Yeah.
You still live on Finette Road?
Yeah.
How long have you lived there?
Huh?
How long have you lived there?
About 3 years.
Are you going to continue to live there for a little while longer?
$8,000.
Okay, your bond was $8,000.
Yes, sir.
Okay, what do y'all want to do?
Well, she's just gonna have to post it. I told them to just give it their bonds and unavoidable if it's a rating type of that.
A lot of times if it's a re-indictment, judge will do something called a rewrite. Or she'll kind of look in and look out, but she won't necessarily have to pay anymore.
Do I have to make an order like a personal recognizance bond instead?
No, if her bondsman is in agreement to do a rewrite.
There's an issue.
Okay, let me know then. Okay, then that's the same bond. Erica Ozan, then please get a resetting. Erica. What are you doing with this one?
This is plain, it's about for
24 CR 2335, Erica Ozan, that's you, ma'am?
Yes.
With Mr. Fender, your attorney and the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
so late here.
In summary, this indictment alleges that on or about August 30th, 2024. In Jefferson County, Texas, you committed a state jail felony of recklessly causing bodily injury to a child 14 years of age or younger. Do you understand what you're charged with? A state jail felony carries with it, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand? An agreement's been reached. In your case, you would be pleading guilty, placed on deferred or unadjudicated probation up to 5 years in length, fined $500, and there will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan here? If I follow this agreement, a bunch of, I'm sorry, no, that's okay. Smudges. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, man? Guilty or not guilty? Are you, yeah, softly. Are you pleading guilty voluntarily on your own free will and because you are guilty? I show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence. Without objection, it's in. This states you are mentally competent to enter your guilty plea freely and voluntarily being made. You understand what you're charged with. The indictment's going to go to you. You read it. You are guilty of the crime charged and any lesser included offenses, and you're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. Or the record for all purposes admitted without objection. Pre-sentence reports waived. I will follow this agreement if nothing further. I'm going to find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the state jail felony. But I'm not going to do that. I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. Please do well. It'll be shortened to a third, and there will be a fine, $500 in terms and conditions of probation, normal and customary for this type of offense. Once again, you do well, it will be dismissed without conviction. If you fail, your probation could be revoked. You could then be found guilty by this court and sentenced up to 2 years in the state jail, which we don't want. Please see the probation officer. Thank you.
Thank you.
I'll be back.
Hey, Reagan, what did you, do you have, what about Xavier Curtis?
He's here, Judge.
In 25 CR 285, what? 284.
Yes, Judge.
What are we going to do here?
I just received an offer this morning. He's basically kind of shifts for money stuff.
3 weeks good?
Yes, please.
Reset?
Yes.
3 weeks, get a resetting. Thank you. Uh-oh, there it goes. No, I didn't throw it. It just jumped out at you on its own. Vicky Holloman?
Judge, I have not been able to make contact.
Vicky Holloman is called in the courtroom. 24 CR 2222.
Can we?
There's no answer in the courtroom. I asked the bailiff to call into the hall for Vicky Holloman, and voice, and she's not here again. I'm going to show you what's marked as state's Romeo Williams. I know somebody spells it that day, and he pronounces it.
Morning.
Give me a name.
I have one this afternoon. Hopefully.
Okie dokie. Romeo Williams.
What's the name, Jeff?
I'm not going to tell you. I'm not going to repeat it because the defense attorney apparently is not here, so we're going to postpone that one to another month, maybe 2026 sometime. Because that's when we'll be able to. I'm sorry, who is your attorney, sir?
Romero Williams.
Yeah, you're Romero Williams. Who is he? Can you point him out in the crowd? That's the guy right there? I don't know. I named you and I said, your attorney, and he didn't want us to come forward. He's shy. He's a shy guy. And we have a lot of issues with him because he's so shy, reserved, and okay. But seriously, here, these are all important cases. 23 CR 1039. Is it Romeo Williams? I know somebody spells it that day, and he pronounces it Romeo. So go figure. Okay, you were charged with a third-degree felony of unlawful possession of a firearm by a felon, and Mr. Tom Burbank is your attorney. Tom, T-O-M Burbank.
Spell his name for me, Your Honor.
It starts with a B, ends with a K. All right. What are we going to do today?
We asked to be placed on the trial docket, Judge. I think we have all of the documentation.
Yeah. All right. So the defendant or his brother, looks like the interested parties here. You want set for trial? It is set for trial. And do you understand, sir, if convicted, you're not eligible for probation? You understand that?
Yes.
Yeah, okay. As long as you know. And I'm sure your attorney told you all about that. Okay, we'll give it a try. This ought to be simple enough and quick, so we'll try to move it up fast. Okay, thank you. Yeah, why not? You're bet. Patrick Pleasant.
That's for a plea, Judge.
Really? Okay, Sam.
I know, I was charged.
Told me amazed. Told me amazed once again.
You signed it.
Mr. President, please raise your hand.
Everybody sign on this one and memorialize it. We'll get it signed.
Black there.
You gotta be careful.
Okay, Patrick George Pleasant. Listen, I'm getting all the names wrong here. I know Pleasance. They pronounce it Pleasant. Some of it.
That was Placella.
Placella. No, that's Plesalot. That's Plesalot. I know that guy. All right, we call 25 CR 49, the state of Texas versus Patrick George Pleasant, present with Tom Burbank. You can't say that present with, say those two 5 times fast and see what you get. With Mr. Burbank, his attorney, and the state's attorney, does the defendant waive a formal reading of this indictment and arraignment? Can we see it in summary?
He does, Your Honor. You may.
In summary, sir, this indictment alleges that on or about August 10th, 2024 in Jefferson County, Texas, you committed the state jail felony of operating a motor vehicle in a public place with a child younger than 15. Do you understand what you're charged with? If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where you would be pleading guilty and found guilty, sentenced to 2 years in the state jail. That would be,
Probated for 5.
yeah, you don't have that checked. After conviction, sentence suspended, and the defendant's placed on probation. And then the community supervision is for a period of
It's 5 years.
up to 5 years. Yeah, I got that other one.
I have,
No, well, it says punishment after conviction, sentence suspended, defendant placed on community probation. Then non-binding recommendation are made, community supervision for a period of 5 years. Well, that's the most it can be.
Yes, sir.
But that was checked. But the other important one, after conviction, sentence suspended, is the binding agreement. This other one was non-binding, but I think y'all want it bound.
Yes, sir.
For him to be placed on regular probation, which we will do. Is that your understanding of the plan? It looks like some other cases are dismissed, the misdemeanor case.
There was a misdemeanor out of this same incident. We're dismissing it.
Is that right, sir? Yes. If I follow this agreement, you have no right of appeal. Do you understand? Yes. How do you plead to this charge? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct? Yes. State's Exhibit tendered into evidence without objection is admitted. So this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Yes. State's Exhibit 1, part of the record, without objection. Pre-sentence report is waived here.
the way.
I am going to follow this agreement, sir. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You were hereby sentenced to the confinement of the state jail for a period of 2 years. That confinement term shall be suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation, which are normal and customary for operating a motor vehicle while intoxicated with a child passenger. You'll be fined $500, and the court will ensure that these other conditions of probation are followed. One of these are going to be a defensive driving course of some sort, which is going to balance out the harm that's done when you commit a crime like this to your insurance. Your insurance goes like this, but we're going to get you on a program that you'll take that'll bring it back down to a reasonable amount. Please follow this. If you fail, your probation could be revoked. The fine's $500. Did I say 1,000? It's 500, right? Everybody, that's what it says on the paper.
That's what I put down, Judge.
I think I told you the wrong. I told her the wrong number, Judge. 500 is accurate.
We're correct.
It's on me.
You're going to use that for that defensive driving class. But it's a gift that keeps on giving. So it's good for everybody to test. Once again, you were hereby sentenced to confinement of 2 years in state jail. That is suspended. You were placed on regular probation for 5 years, fined $500. Other terms and conditions of probation will be required of the probation officer. We'll go over all this. Please do well here. If you fail, your probation could be revoked. You could be sentenced up to 2 years, which you don't want. Nobody does. So run through the tape. Right? Win the race. There we go. Thank you. Please see the probation officer. Thank you, sir. Derek Holman.
Sure. Hold on.
Okay. I have Jared.
Yes, sir.
Holman here in 24 CR 2471, charged with a third-degree felony of unlawful possession of a firearm by a felon.
Yes, he was placed on trial.
Really?
Yes.
These never get placed on trial.
Well, today it was Dawn's in possession.
Okay. All right, set it for trial. Shall be done.
May he be excused to that day.
Yeah, he just needs to get a reset.
I have one more.
Edwin Jones.
Yeah, Mr. Jones.
You did Patrick. What's that?
Some time.
Okay. 21 36867 is called Edwin LaPaul Jones. That's you present with Mr. Burbank, your attorney and the state's attorney. I have an order on a motion to withdraw. That's been withdrawn.
I'm not doing that.
Motion to withdraw is withdrawn.
Correct, Judge. We're seeing hopefully eye to eye on a lot of things. And
what are you still at 445?
Magnolia Trail in case.
Yeah. No.
I think we're closer to a resolution of this week. You have about 3 or 4 weeks? Get it?
Yeah, month to
figure it out.
45 days.
6 weeks?
Yes, sir.
All right. Get a reset him, sir. Thank you.
You're strong.
I'm
telling you.
We took care of Zane Buren already. And this page is done.
Right.
Sir?
I have another one.
Who is it?
It should be Winston Giles. Mr. Giles?
Winston Giles. 24 CR 1157. You were Winston Giles?
I'll look it up for me.
Princeton Andrews. You were charged with the third-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison if convicted today. Yes, what are we doing?
Just for a full week. They've made an offer.
All right, you got it.
I had some questions in reference to the tape, and I just need time to talk to them.
Okay. You got it.
Maybe excuse to that.
Mister, I've got Michael Frost. Mr. Michael Frost. And come on up.
Okay. I don't know how I that's all.
We have a prosecutor up here on this. It's Mr. Frost again. What are we doing? What are we gonna do here? Is
I'm having all that paperwork. Legit.
yeah. Okay. Do you solemnly swear or affirm all the contents here are true and correct? So help you God.
Yes.
Yeah, I find that the defendant is eligible. Court-appointed lawyer will be provided for you, sir. And Mr. Turk is right there. He can give you some advice right now. He's one of our public defenders, very sharp guy. And talk to him, and then he'll let us know what is planned for the next event. Okay, now I'll just hold this in abeyance, but walk through this carefully because you've got the prior conviction here. He's got a prior conviction, Brent, that he's got a prior conviction out of 93 here that would enhance it to a second-degree felony. But once again, that's 32 years ago. What do they say? What's in the past is never really in the past. That's all it's saying. All right. Next is I have Jose De La Rosa. You're Mr. De La Rosa.
Yes.
Okay. You were charged here with the first degree felony, illegal possession of child pornography, which if convicted, of course, carries with it at the life imprisonment. So it's one of these things you've got to navigate through delicately. What are we doing today?
Put it on trial docket here. We made him a pen time offer. I mean, it's not
okay.
Except you.
Okay. Is there anything special about this punishment range on this particular case?
No, Your Honor.
That we need to be aware of? No, it's just regular first degree felony?
Yes.
Okay. All right.
Excuse, Judge.
Yep.
Sure.
Did you get your receipt?
Resetting. Right there, I'm highlighting that.
I need to get to bring your deals.
Yeah.
Thank you.
Back there, I need to get my phone.
Oh.
Not on the highlighted X for me and put a good working telephone number up under your name.
What happened on Kiana Walker?
Right there, and then put a good working.
What happened on Kiana Walker?
That's something familiar. I'm just trying to think about what it is.
That was Don Dusler. But
She was gonna plead, but they had her. Restitution or something from a code offense?
Yeah.
okay, that needs to get resolved somehow.
You can say some name.
Okay.
There you
I
go.
wondered there was, and then Leonardo Mendoza.
That's this afternoon.
Okay, so I'm about to file that one out. Okay, we're in recess 1:30, correct?
Correct.
All right, see everybody.
Anybody that has any case ready or might just gonna call cases and have nobody respond today.
Judge, we're ready on Kenneth Abo. I believe the prosecutor's sending the file to the court.
Okay, as soon as I get that, I will call the case. I've called 3 or 4 in a row and nobody's responding.
Your Honor, I think we need to get into the breakout room with the prosecutor.
Okay. Okay, Mr. Palazzolo, you want to go in with Mr. Mohammed?
I need to go to the break-in room. For the break, I need to see the city attorney.
The Wayne County prosecutor, right?
I think it's a city case, I believe.
What's the name of the defendant?
Quafa, QAFA, Adrian, the traffic matter.
It's got to be the Wayne County prosecutor, unless we. All right, we'll get you in a breakout room, Lisa, with Mr. Muhammad, I suppose.
Thank you, Your Honor.
No problem.
Excuse me, Your Honor. I didn't want to speak. I didn't want to speak at the time. I just want to know if I can ask you a question.
No, you can't ask me a question. I'm sorry. I didn't call your case. I need your lawyer here, okay?
Right.
Detective.
Good morning, Your Yeah. Right there, John.
What is going on out there today?
They say join, I want to press and you get it join. I don't know something there. Judge.
What?
You demoted.
I'm a detective today. You didn't give me a promotion today. You're not gonna have to go home now.
You're not just a lieutenant or inspector. Now I demoted you, right?
Well, next time it's colonel.
Kenneth Scott Bebo, 25I-722-550.
Good morning, Judge. Jeff Perlman on behalf of Mr. DeBow.
Where is he?
He's on Zoom. When I talked to him, he's in the waiting room.
I'm telling you, I'm losing my patience here. Mr. Thibault, you have to start your video. You have to start your video, sir. Thank you. Your name?
Kenneth Thibault.
So you guys send this in, you got a CCW, and it's going to be, there's going to be a plea to improper transport. Is this the 90-day misdemeanor under 750-227D? Mr. Perlman?
Those days.
They're driving me crazy today. Mr. Perlman, can you hear me? Everybody's frozen. Wait 1 second. Call in the prosecutor, the Wayne County prosecutor, please.
Judge, you hear me?
I can hear you now, but you're still frozen, and I need to get some clarification from the prosecutor. And my question was, is this going, you got a reduction from CCW to improper transport of a firearm? Mr. Muhammad, your name?
Good morning, Your Honor. Muhammad on behalf of the people.
Where are these guys going to? I don't understand where everybody's going to. I've called all these cases you've sent in. Are they out in outer space or what are they doing today? That's the first question. The second one is, you send me a plea form, improper transport of a firearm. Are you talking about the misdemeanor 750.227D, which is punishable by up to $100 in fines, 90 days jail?
Yes.
Okay. All right. Mr. Pearlman, is that your understanding as well?
Yes, Judge, and we are asking for the court to consider Haida at sentencing. My client's 25 years old and has no record.
Did you talk to the prosecutor about that?
Prosecutor
I don't
said he
really
would-
get involved in taking statutes under my own. I don't really do that. So if you want to do that, you better talk to the prosecutor now.
Well, the prosecutor indicated that he doesn't have discretion and that it'd be the court's discretion. So.
Judge, I don't have the discretion to extend Haida as part of the plea. Defense counsel and reach out to the supervisor. It like and set that way, but I'm not in a position to make that.
They don't let you offer Haida?
Correct. Without supervisor speaks that, I'm not allowed.
So I just had one the other day where somebody got Haida on something that's so much more serious downtown. I believe it was GBH.
Judge, based on the
I don't care, but I'm not going to do it on my own. So
I understand. And based on the representation by the officers associated with this case, I think the defendant would be a good fit. They've indicated
then
that.
why aren't they giving you discretion to do the right thing? This is not.
We could adjourn and I can reach out.
Now I'm going to take the plea and we're going to have a PSI and then you can come back and tell me. I'm going to set it on a sentence date. Okay. Mr. Thibault, if you plead improper transport of a firearm, that is a misdemeanor punishable by up to $100 fines, 90 days jail, costs or all those. Do you understand that, sir?
Yes, sir.
And you are presumed innocent and they have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand me?
Yes, sir.
And is this how you wish to proceed?
Yes, sir.
All right. To the charge of improper transport of a firearm, how do you plead?
Guilty.
Well, he's got to say it, not you. Huh? How do you plead, sir?
Guilty, sir.
Were you on September 18 of 25 in the township of Grosio on Meridian near Grove?
Yes.
Were you in a motor vehicle?
Yes, sir.
And was the fire? You had a firearm, correct?
Yes, sir.
What kind of firearm?
Smith & Wesson SD9 VE.
Where was it located?
In my glove box.
Was it loaded?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Did you have a permit to carry that weapon?
No, sir.
I'll accept your plea. I find it to be an accurate plea. Improper transport of a firearm, the CCW on motion of the prosecutor is dismissed. I'm going to order a pre-sentence report. So you're going to have to come over here today and get interviewed by the probation department. Mr. Perlman, you're going to have to talk to the prosecutor's office. We'll set about Haida. We're going to set this over to October the 25th at 8:30 in the morning. Okay?
Well, thank you, Judge. I think October 25th, is that
October
Saturday?
14th.
Oh.
10, 14,
so I'm going to be,
two
Judge, I'm going to be out that day and
October 21.
That'll work.
Okay. October 21, and we'll do that at 8:30. Okay.
Thank you, Judge.
I'd really like you. You're retained. I'd really like you. I'd really like you in person. If you can't, and you got to do it by Zoom, he's going to have to be in your office. Okay.
That's fine. Yeah, that day I would have to do it on Zoom, and I'll make sure he's in my office.
Okay, good enough. Thank you very much.
Thank you,
Have a
Judge.
good day.
You as well. Bye now.
Is Craig Averill here? Is Premier Truck Sales here? Is Mr. Newman your appearance? Craig Averill. Let's take his. Craig.
Yes.
Yale Averill, 25D815913. Your name?
Craig Averill.
You're going to plead to failure to exhibit a fishing license, right?
Yes, sir.
That's a civil infraction. To that charge, responsible or not responsible?
Responsible.
I'll accept the plea, $10 conservation fee, 150 in fines and costs is $160. It says you need a payment plan, right?
Yes, sir. I just got on unemployment, so I probably won't get paid until like October 10th for my first payment.
Okay. Can you pay 50 a week starting October the 13th?
Yes.
You pay $50 each week beginning October 13th, okay? If you need more time, all you have to do is call the court. We'll go on Zoom on or before the due date, or you can walk in here on or before the due date at 8:30 in the morning, and I will give you an extension. I don't care how many times we have to do that, as long as you don't ignore me, all right?
No problem, sir.
Have a good day.
You too.
Mr. Newman, I need you to state your name, sir. Gordon Edward Davis, 25M587295. You got to pull over, Mr. Davis.
There, I apologize. It's first time using Zoom. I'm pulled over, sir.
Your name?
Gordon Davis.
The officer failed to appear. I gave him 15 minutes. It was scheduled for 9:30. It's now 9:51.
Okay.
Case dismissed.
Thank you.
Good luck.
Thank you, sir. I appreciate you. Bye-bye. I don't know how to leave. Here we go.
Do I have Ms. Trombley out there, Lisa? Good morning, Premier Truck Sales, 25SO26894. How are you, Ms. Trombley?
Good, Your Honor. Elizabeth Trombley appearing on behalf of Premier Truck Sales.
All right, so you're authorizer in this plea overweight. You and the prosecutor have agreed to a plea with agreed upon fines and costs of $950, true?
True, Your Honor.
All right, to that charge, responsible or not responsible?
Responsible.
And you're authorized to enter that plea, correct?
Yes, Your Honor.
$850 per the agreement of the two of you, pay by October 30.
Okay, thank you, Your Honor.
Thank you very much.
Have a good day.
You too. Take care.
Thanks.
Lisa, tell Mr. Newman by chat, I am adjourning it until October 14th, that it will be a formal hearing and that they have to be in person. I'm not going to call his name 19 times today, okay? So we're setting a formal hearing, and I want it all over the notice. This is People Against Harmanjot Bangu, 25M8586038 A, B, and C. Since he didn't bother to come on, I'm not gonna adjourn this. So no adjournments, tell him. I've called the case at least 4 or 5 times. I'm going to set it for October 14th. Formal hearing, 8:30. Must appear in person. Must appear in person. Okay, so make sure that's all over his notice. DeAndre Bernard Madkin, 25 T721756. What in the world is going on out here today?
We're in a breakout room.
Okay. Do I have Jorge Caballero out there? He sent this one in too, without anything. Jorge Caballero. 25M580751A and B. Adriana Caballero, if that's you, I don't know if that's your husband, if your husband, that's your husband, whatever. Jorge Caballero, you need to you need to unmute and state your name if that's you on the iPhone. Your name, sir? You got to unmute. Bottom left-hand corner.
Hello. Good morning,
Jorge, listen to, let me call the case again, okay? Jorge Arturo Caballero, 25M580751, A and B. Your name?
Jorge Caballero, sir.
So you're charged with a motor carrier violation and then improper log, it looks like.
Yes, sir.
You have the right to a lawyer on these. If you want, I can give you one. You can go in a breakout room with the lawyer and the lawyer will go talk to the prosecutor for you.
No, sir.
Okay, I'll just arraign you. Those are the two charges. This allegedly occurred on I-75 and you're here in River Drive in Rockwood. Both are misdemeanors. Both of these are punishable by up to 500 fines, 90 days jail. Well, the log charge is a civil infraction, but the first one's punishable by up to 500 fines, 90 days jail. Costs are all three of those. The second is a civil infraction. Do you understand that?
Yes, sir.
You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
No, sir.
You want a lawyer now?
No.
Okay, so you do not want a lawyer?
No, sir. Do I need?
Okay. Okay, a personal bond, $100. You live in Texas, right?
Yes, sir.
How's the weather there now?
It's good, sir. It's about 80 degrees this morning.
Well, that's nice. All right. So you can leave the state to go to Texas. You cannot violate a law. You must appear in court as directed. I'm going to put the prosecutor and you in a breakout room, or my staff is rather. And then you can talk to the prosecutor, see what you can negotiate. And then either way, you're going to come back in front of me today. Okay?
Okay.
You understand that?
Not quite well. Can you explain it again, sir?
Sure.
I've never been in a court. I'm kind of nervous.
Good. Unless you're a judge, you're a police officer or a lawyer, you shouldn't want to be. Anyway, you're going to go talk to the prosecutor in a breakout. You're going to see what you can negotiate with him. I'm sure he's going to be fair with you. If you don't like what he's offering you by way of a plea bargain, maybe a dismissal of one, maybe reduction of one, I don't know, or reduction or dismissal of both, whatever you want. If he doesn't give you what you want, come on back in here, talk to me, and I'll give you a lawyer, okay?
Okay.
Fair enough?
What is the worst case scenario? How bad is
Go talk
this?
to the prosecutor. I don't know what he's got in mind. I don't know what he's got in mind. I told you the maximum penalty. Okay? That doesn't mean I'm going to send you to jail. I mean, but I told you those, I have to tell you the maximums. Go talk to the prosecutor, see what you can negotiate with him, and we'll go from there. Okay?
Okay. Your Honor, can you please repeat the maximum?
It's up to these are the maximums. Up to 500 fines, 90 days jail, costs, or all three of those penalties. That's on the count one. But go talk to the prosecutor. This is not a case where I'm sending you to jail. So if you're getting nervous about that, please don't. Okay?
Yeah,
all right. Go talk to the prosecutor. Thank you.
Thank you.
Mr. Newman, you gotta come online when I call your case. You're not gonna make me call your case 6 times, are you? Give me the files on Newman. Please. Mr. Newman,
Good morning, Your Honor.
why are you making me wait so many times? I see your name on the screen. I've called the case 6, 7 times. Give me a break. Come on, I got better things to do than chase you around. There's 3 files. It's Bango or
Oh, my God.
people against
I apologize, Your Honor.
Hermanjo Bango, 25M586038 A, B, and C. Your name?
Morning, Your Honor. May it please this honorable court, Attorney David Newman appearing on behalf of the defendant, Harman Job
I'm
Bangu.
gonna get agitated too easily, but I hate when lawyers do that. You can't just leave me out here like I'm like 19th in line here. Come on, all I have to do is set a hearing. I'm setting it for October 14th. It's going to be in person. It's a formal hearing, and I'm not going to adjourn it again, okay? October 14th, 8:30.
Thank you very much, Your Honor.
We'll see you here then. Thank you.
Sorry again. Yep,
It's
take
all
care.
right.
Thanks. Bye-bye.
Madkin. Is DeAndre Madkin here? Mr. Cooper out there?
He was concluded.
I know, he was, then I was told he's in breakout room, but. Mr. Wolak, I'm sorry, what do you have?
Good morning, Your Honor. I have Louis Miller, should be present from the Wayne County Jail. I did need a breakout room with him for a minute.
You need a breakout room?
Yes, please.
He's not on screen yet.
Oh.
Morning.
Morning.
How are you?
Did you guys get a new date for Herman Jot? The case you got?
Yeah, October 14th,
October 4th.
8:30, in person, formal hearing. Okay, thank you.
Oh.
Judge.
How you doing? I'm good, yeah.
Court executive session.
What's going on with you?
Judge, what I got for you?
Oh, I know, I keep
I
forgetting.
was wondering about it.
Yeah, thanks.
Uh-huh. Perfect timing.
Yeah. What,
Mm-hmm.
if you have a deal, hey, tell me where I started.
Megan's ready to go. So these were just put up. So Megan is in jail and